have to look between the lines. You don't have to say, well, maybe, possibly that's what it was over. We know that's exactly what it was over. As flashy and as sensationalized as that sounds, that's what happened. And we know that. How is it that we know that? Because people, 2 to 3 people in the theater heard this defendant say that right after he shot and killed Chad Olson. Derek Friedoff, Mark Turner, and to some extent, Charles Cummings. These 3 people do not know each other. Derek Friedoff was sitting a row in front of the Olsons and to the left. Mark Turner was sitting all the way to the right in the defendant's row. Charles Cummings was sitting a row in front of Mark Turner. All across the theater, they heard the defendant say, "Throw popcorn in my face." That's why we know this case is truly about a man killing another man over a popcorn toss. These 3 people, Derek Friedoff, Mark Turner, Charles Cummings, they don't know each other. They're not friends. They're not family. There is no evidence that would lead you to reasonably believe that they got together to frame the defendant, that they got together in the theater and they huddled together and they said, you know what? We don't know Curtis Reeves, but let's make up a story that he said, "Throw popcorn in my face," or some words to that extent about the popcorn. It would be completely unreasonable to believe they got together to frame the defendant. Some grand conspiracy. This case is absolutely, unfortunately, about a man killing another man over a popcorn toss. Now, you don't have to really read too much between the lines or go very far below the surface to determine why this happened. Now, when I say this, I am not saying this as an indictment on law enforcement in general. We are only talking about the defendant. And what do we know about the defendant? Well, there's certificates and evidence. A career law enforcement officer, trained in de-escalation tactics, not only through the department, but through Busch Gardens. How you take a volatile situation, and I submit to you this wasn't even a volatile situation, but how you take the most volatile situations and you de-escalate it, lower the volatility. Yet, despite all that training, instead of de-escalating the situation, the defendant instigated the situation. The defendant started it, and he stopped it. And what you have to look at is what's happening here. Here's an individual. The defendant is a person that I submit to you based on the evidence likes those danger situations, likes the adrenaline, the units that he was involved in. He likes the control. Now, I'm not saying there's anything wrong with leadership. Of course there isn't. That would be silly to say. But likes the danger and likes the control. And that's how he started this, that's how he instigated it, and that's how he ended it. And that's what this case is about. It truly is about a man who killed another man over a popcorn toss. Now, the defendant wants you to believe this. And I submit to you that both versions of the events that the defendant told you are absolutely 100% not credible. And I submit that you know that already. The defendant wants you to believe this. A retired captain from the Tampa Police Department who's been involved in robbery, homicide, fugitives, the Special Weapons and Tactics Team, also known as SWAT. Remember during his testimony what he said. Man, it's eye-opening. When I first started, the level of violence and the dangerousness, you wouldn't believe it. Yet that very same person wants you to believe that in all his years, doing all those jobs throughout Tampa, that scared him the very most, the one person that he had to shoot and kill, was in theater number 10 on January 13th of 2014. The person that scared him the most is a father and a husband that said, "Leave me alone, I'm texting my daughter." Maybe he threw an F-bomb in there. You can't kill anyone for an F-bomb, that's for sure. Is it reasonable to believe that that person, Chad Olson, scared him the most in his entire life in that moment in theater number 10? I'm texting my daughter. He reaches and he grabs a popcorn and he throws it at him. In his entire career, that's the most he's ever been scared. Absolutely unreal and unbelievable story. The defendant in this case shot completely out of anger. And we know that because of the words that he stated afterwards. And not only that, you're going to have the videos back there with you. You're going to have the state video, you're going to have the defense video. They're both basically the same. Very minor differences. Watch the reaction that the defendant has when he's shooting, because that demonstrates the anger, the explosion, and that's why those words come flying out of his mouth immediately after he shoots. He lunges forward. He's not back in a life or death struggle like he wants you to believe. And we're going to talk about his stories. That is absolutely not what happened. He lunges forward. And how was he able to do it so quickly? Because when he was moving back, that gun was at his hip already. That's exactly what happened. That's how he was able to fire. He already had it at the ready. But we're going to talk more about that later. Now, when he's interviewed in the cruiser, think about this. Now, you have that tape statement. Listen to it as many times as you want. Okay? And again, those videos are on the computer. You're going to have a computer that's going to go back with you. So you're going to be able to look at the videos. There's a player. You can move it back and forth like we are doing on cross-examination. When you listen to that post-Miranda statement, think about it. Now, you have to rely on what you believe is in that statement. I submit to you it shows a cool, calm, and collected person telling an unbelievable story in order to justify what he had done. A very self-serving statement, and a self-serving statement does not equal self-defense. A retired police officer sitting in a cruiser, cool, calm, and collected, making up a story that is contradictory to every witness in this case. There are 7 to 9 eyewitnesses in this case, including 2 that the defense called. And none of them even remotely touch the story that the defendant wants you to believe, including his wife. Sitting right next to him, inches away. She didn't see some violent life or death struggle. Do you think that she would have noticed something like that? Of course, because the defendant's story is 100% untrue. A self-serving story. Now, why did he tell that story? It's a great question. I submit that he told that story because he had no idea that so many people observed what happened in that theater. But here's what he really didn't expect. The silent witness. Who was the silent witness the defendant never in a million years thought was going to speak the loudest words in this case? It was that video. I submit he had no idea there was a video in there. The silent witness spoke the loudest because when you watch that video, every single thing that he said was untrue. Every single thing. And then he came into court and took that stand and looked you in the eye and told you a completely different story from the unbelievable one in the cruiser. Why is that? Because he knows what really happened on January 13th of 2014. Just like the witnesses that came in and told you. Just like the video tells you. He shot and killed a man over a popcorn toss. He started it and he ended it. End of story. Now, we had a jury trial the past 3 weeks. When we have a jury trial, the state, sometimes people call us the government, okay, but it's the state of Florida. It's the 3 of us prosecuting this case. We have to prove the case to you beyond a reasonable doubt. That's our burden. We gladly accept it. It should be that way. Now, what is a reasonable doubt? At the conclusion of the case, you're going to hear all of the law. I get a copy of the packet as well. You don't have to memorize the law. It's kind of complicated. We're going to go through it. I have a lot of boards and an easel. We're going to go through the law. Okay? Now, a reasonable doubt. This is part of the instruction. A reasonable doubt may come from a lack of evidence, and it may come from a conflict in the evidence. Now, I submit to you there is no lack of evidence in this case. 7 to 9 eyewitnesses and the video. And the defendant's self-serving statement. It's almost like when someone says they didn't commit a crime because they have an alibi in another county, but then it's proven that they're in the county. It's like, Why make up such a story? A conflict in the evidence. Let's talk about that. I submit to you, whenever there's a jury trial, there is a conflict in the evidence, right? I mean, just the very nature of a dispute is there's a conflict in the evidence. And that's not a reasonable doubt in and of itself. Because if you think about it, then you could just have some people come in and say, well, I said it's red, this person said it's blue, conflict in the evidence. How would you ever prove a case? You couldn't. So what do jurors do? Obviously, what a juror does is you take all of the evidence. There's a lot of evidence in this case. And you got to sift through it. You got to look at it. You really got to analyze it. And you got to say to yourself, what evidence here is credible? And Judge Barthel's going to read you an instruction. And what she's going to say is you can believe all of a witness's statement. You can believe none. You can believe some of it, discard some of it. That's totally up to you. And what's interesting about this case is we have a mixture of all of that. There are witnesses where you can believe everything they said. You could take some of what people said. Vivian Reeves' testimony, Jennifer Shaw's testimony. You could take some of that. Others of it, I submit, you're going to have to discard because it's certainly not credible. Ultimate bias in that. But we'll talk about all this. You could completely disregard a statement. Both of the defendant's statements are completely unreasonable based on the totality of circumstances. He didn't fear anything. He wasn't vulnerable. He was an instigator. He started it, and he ended it. So just a conflict in the evidence isn't a reasonable doubt. You have to take all the evidence, find out what's credible. So what you do is you take the not credible evidence, you put it aside. You take the credible evidence and you look at it. And we're going to go through the elements of the crime. So you take the credible evidence and you apply it to all the elements. And what you do is you start with the highest crime charged. And again, we'll talk about all that in just a little bit. But you take the credible evidence, you apply it to the law, that's how you come up with a just verdict. Now, the other instruction that is contained within a reasonable doubt is this. A reasonable doubt is not a forced doubt, an imaginary doubt, a possible doubt, or a speculative doubt. Okay, I'm going to repeat that because it's really important. It is not, and the most important two are possible doubts or speculative doubts. Those are not reasonable. So there's a story that I tell for every closing argument. Obviously, I'm going to tell it today. So let's say that it's the summertime and you're out walking your dog and it's nighttime. And you hear thunder, you see lightning, you smell rain, and you go to bed. When you go to bed, you wake up. And your neighborhood is soaking wet. Has it been proven beyond a reasonable doubt that it rained? Absolutely. Because common sense tells you that. And remember, you don't leave your common sense at the door. Thunder, lightning, smell of rain, your common sense, it's been proven beyond a reasonable doubt it rained. Now, is it possible the neighborhood kids went walking around that night when you were sleeping? You got Christine, you got Carol, you got Jeff, and you got Bad Brian, okay? Now, is it possible that Bad Brian went out and took a super soaker gun and sprayed the whole neighborhood with water while you were sleeping? I mean, you could talk about that any day. Is it possible the sun's not going to rise? Based on the evidence, thunder, lightning, smell of rain, and your common sense, basically what comes from the witness stand and what's in evidence, it's been proven beyond a reasonable doubt that it rained. It's not possible Bad Brian did that super soaker thing. That's ridiculous. That's not reasonable. Now, can you speculate that a helicopter went over the neighborhood with a bucket of water going to a fire and that the bucket of water landed on the neighborhood? Sure. But based on thunder, lightning, smell of rain, and common sense, that is completely unreasonable. Can you speculate your car's not going to start tomorrow? Sure. But that's unreasonable. So those doubts are not reasonable. So you got to be careful when you start getting into possibilities and speculation. You have to focus on the credible evidence. So let's talk about speculation because there's so much speculation in this case. It's really important to talk about it up front. I'm going to call these speculations shiny objects. Because what happens with a shiny object? See, if you look at a shiny object, let's say there's a whole bunch of shiny objects floating over here. If you look at those, you're going to forget to look over here at this table where all the credible evidence is. And when you look at all that credible evidence, I submit you're going to find the defendant guilty of either murder in the second degree or of manslaughter. Because these shiny objects, if you look at them, you lose focus of what really happened in this case. So I have a list. It's a fairly long list of shiny objects. Now, if a lot of questions are asked about a shiny object, or you yell about a shiny object, the only thing that happens is this. It doesn't become any more relevant, and it doesn't become any more important. It becomes shinier. That's all that happens with shiny objects. So let's talk about all the shiny objects, the unreasonable doubts in this case. The sheriff's office should have recreated the scene, and the theater was too dark and too loud. That's a shiny object. First of all, it'd be impossible, literally impossible, to recreate that scene. The best law enforcement agency in the world couldn't recreate that scene. And why is that? Because think of all the moving parts. You'd have to know where everybody was seated. Not only that, what angle they were at any given time, because every angle would be important. Where the Olsons were, where the defendant was, where all the witnesses were, what the exact scene was at that exact time, while they were in that angle, while someone was talking or not talking. Every single thing would matter, and you can't recreate the scene. It's impossible. A light meter wouldn't tell you a thing. A sound meter wouldn't tell you a thing. Who tells you? Witnesses. They take the stand under oath. They tell you what they saw, what they heard, and none of them got together to frame anybody on January 13th of 2014. It's impossible to recreate the scene. So when a paid witness for the defense gets up there, Michael Knotts, and talks about recreating a scene, it's impossible. We wouldn't bring that to you. I submit to you there would be a very long cross-examination about it. Like, how could you possibly tell this jury that this scene could be recreated? Plus, how would you even document that? A camera would never in a million years ever tell you what an eyewitness can tell you. Just can't happen. It's a shiny object. Now, was it too dark? Remember at the beginning of opening arguments, I said, hey, please make sure that a witness is not pigeonholed into one word. Remember, muted, dim, dimmer, dark, darker. But one word means nothing. What's important is the picture that's painted. And you saw it happen during the trial. Now, what did all the witnesses tell you? Even Joanna Turner, and we're going to talk about her. All of them told you, yeah, it was dark. It was muted, it was dimmed, but we could see. We could see. We could see 5 seats down. We could see 10 seats down. When we get into the theater, we can see. That's the real evidence in this case. And what they saw was the defendant start it and end it. What they saw was the defendant kill another man over a popcorn toss. Now, could they hear what happened? Oh, it's so loud. The previews are so loud. We couldn't possibly hear it. Well, that's not true, because every witness came in here and they told you, yeah, previews are on. But we could hear. Now you think about the layout of where everyone was in that theater. You have the defendant with his wife sitting in the back row. Directly in front of them is the Olsons. Going back into the defendant's row all the way to the left are the Hamiltons. They could see, they could hear. You go all the way to the right, you have the Turners, Joanna and Mark. They could see, they could hear. Even closer is Jane Roy. She could see, she could hear. Then you have the Olsons. To the right of the Olsons, you had Charles Cumming. He could see, he could hear. Then in front of the Olsons, you have Derek Friedoff. He could see, he could hear. Nicole Olson, even Vivian Reeves. There's not a question if it's too dark or it's too loud. Now, there was an interesting moment, though, in the trial. There was a very interesting moment. Okay, you remember Matt Reeves, and we're going to talk about Matt Reeves. Okay, I would submit to you that Jennifer Shaw and Matt Reeves were in a tough situation. They were credible and not credible at the same time. But Matt Reeves said something that was really interesting. Now, think back to the defendant's first statement in the cruiser. Again, it's an unreasonable statement. Didn't happen. I mean, it absolutely didn't happen that way. But think about what he said. He said that while he's leaning back in this life or death struggle, He's yelling what? What's he yelling? No, 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 and whoa, whoa, whoa. What's Matt Reeves say that he heard when he came into the theater? Now, you rely on your own recollection. I could be paraphrasing it. He said two different things, but he said, I heard, get out of my face, or something like that. And then defense counsel asked him, well, how did you recognize it? Well, it's my dad's voice. Of course I heard it. Now, think back. I'm sure you know where I'm going with this. Think back. Who in this case said that somebody said at that point in time, get out of my face, or words to that effect, stay out of my face? You can't confuse no, no, no and whoa, whoa, whoa with get out of my face. But who told you that was said by somebody?
Come back into the movie, and the guy put his phone away, and as I went by, I said, I see you put it away. I told the manager for no reason. In other words, I went in and ratted him out. If he was going to put it away, I would have gone, Right. And he turns around in his seat, and he says something about he was, I don't remember. If it was any of your fucking business, I was texting my daughter or something like that, and you stay the hell out of my face. I think that's when he said that.
Okay. So who is saying that someone is saying words that are close to that? The defendant. So was Matt Reeves able to hear Chad Olson telling this defendant, basically, stay the hell out of my face, leave me alone, stop instigating me, just leave me alone? So was it really too loud? Or did Matt Reeves come in here just to try to say the defendant said it because he wanted to help out the defendant? Matt Reeves is also the only witness that said it was nearly pitch black. Not a single witness told you that. Not a single witness. The sheriff's office investigation, a shiny object. In fact, it was a super shiny object. We heard many witnesses. Extensive cross-examination. There was a suggestion that the sheriff's office investigation was bad. I'm going to use a very non-legal term here. There's a suggestion that the sheriff's office investigation was crappy. You know what? The sheriff's office investigation was crappy. Absolutely. It was a terrible investigation. There's no doubt about that. You could bring in one witness, you could bring in 50 witnesses. There's not a single person that would listen to this case and say, wow, they did a fantastic job. They did not. Absolutely did not do a great job. No doubt about that. But it's an incredibly shiny object, a super shiny object to take you away from looking over here. Because in reality, it doesn't mean a single thing in this case. Now, do we want law enforcement to do a great job? Of course we do. You kidding me? But in this case, it didn't mean a thing. Because we brought in witnesses, eyewitnesses, credible eyewitnesses. And you saw how they were cross-examined. They were tested. It doesn't mean a thing that the sheriff's office didn't do a great investigation. Think about all the witnesses that testified in this case. I'm going to try to name the most important witnesses. You had Nicole Olson. You had Vivian Reeves even. Her testimony kind of meant something because what she doesn't tell you speaks volumes. Jane Roy, Joanna Turner, called by the defense, Mark Turner, the Hamiltons, Angela and Alan, Charles Cummings, Derek Friedoff, 9. They came and told you what happened. It doesn't matter. Let's say the sheriff's office, just for the sake of argument, asked one question of each of those witnesses. Does that mean when they came in here and testified about what they saw and what they observed, it doesn't mean anything? Of course not. It doesn't matter in this case. Not a single bit. You could just remove the sheriff's office from the whole case, in this case. Now, there are some investigations where it really does matter. Thankfully, it's not this case. It's a big, shiny object. We absolutely agree they could have done a better job. Not only do we have all those witnesses, we have the silent witness, the video, that tells you what had happened. The detectives, this is shiny object number 3, the detectives didn't have the qualifications. They didn't know enough about self-defense to be involved in this case. All right, let's talk about that. Doesn't mean a single thing. Okay? You have a defendant here who has all this law enforcement experience. It's not some unsophisticated person that for the first time he's ever been interviewed. And when you listen to the post-Miranda statement, he's asked plenty of questions. But let's say he was just asked one question. Do you really believe that this defendant didn't understand what was important to tell the detectives and that the interview was the defining moment? He knew enough to make up a story to justify an unlawful shooting. Perception distortion, he's throwing out this terminology. He knows what's going on. Perception distortion is not an attack that never happened. Okay? That's just being untruthful. It has absolutely no bearing in this case at all. It's a shiny object, means nothing. So when their paid witness takes the stand and says, oh, you'd like to ask them these questions, at the second time, when, and it's on tape, Detective Proctor, when he goes back to him, he says, hey, is there anything you want to tell me? No. But you know what he does says? You know what he says? We'll talk about it again later. You know, I'm back here, and I'm second guessing. You know what? I'm not sure he hit me. This incredible hit that scared him to death, that no one saw. I'm not really sure that happened. That's what he says. You don't get second chances when you kill somebody. It's a shiny object. Shiny object number 4, witness contamination. You can talk about it with 50 witnesses. You can yell about it. It means nothing. It becomes shinier. There is no evidence at all of witness contamination in this case. In fact, we have so much evidence against it when you think about it. Okay? First, you go with the basic premise, no one really knew each other, and they wouldn't get together in the theater to conspire to frame Curtis Reeves. Well, then you might say, well, maybe they just absorbed some information and it was planted in their mind like inception, and now they're testifying. That is ridiculous. That's the very definition of an unreasonable doubt. And you had an opportunity to see them on the stand and judge them and observe how they were testifying. But here's the point that I'm making. Think about Joanna Turner and Mark Turner and that testimony. Joanna Turner, some of what she said I would state to you is credible, some is not credible. And we'll talk about Joanna Turner in a little bit. But with witness contamination, that shiny object, think about this. They lived together. Joanna Turner said she spoke to Mark Turner. She shared her information about this thermos that just for whatever reason she believes there's a thermos somewhere. Well, we know there's no thermos. She said it absolutely wasn't a cell phone. We don't know what happened there. But my point is this. They shared that information. Did Mark Turner come in here? Did he take that stand and say, oh, I saw a thermos too? No. It's the opposite of witness contamination. She shared information with Mark, but they testified differently because they came in here under oath. They told you what they saw, what they heard, and what they observed. It's the opposite of witness contamination. It's what's supposed to happen. It's a very shiny object, witness contamination. It sounds terrible, but it didn't happen. And there's no proof at all. Well, there's people sitting at a table. Who are these people? Any proof Derek Friedoff got with Mark Turner, or that Mark Turner got with Charles Cummings, or Charles Cummings got with Alan Hamilton? That's pure speculation and an unreasonable doubt. It's a shiny object. All right, shiny object number 5. Detective Proctor interviewed 2 witnesses, which are the Hamiltons, for 5 minutes off tape. What does that mean? That means this. Detective Proctor interviewed 2 witnesses off tape for 5 minutes. That's all it means. They came in here and they testified. Shiny object number 6. We already touched on that. The detective's interview. Maybe they weren't asking the right questions. The defendant knows what he had to say. He made up an entire story. The witnesses came in here. They told you what they saw, what they heard, what they observed. Shiny object number 7. A holster was in Detective Proctor's drawer for 1 week locked up. Oh my goodness, there was a holster in his drawer for a week. So what does that mean in this case? What does this shiny object mean? It means this. There was a holster in Detective Proctor's drawer locked up for a week. That's exactly what it means. Now, if this holster was important because it was a whodunit case, because there was blood or something on it, and it would degrade in his drawer for a week, well, then it's a big deal. It wouldn't be a shiny object then. It would be a big deal. Is this case about the holster? Or is this case about the defendant shooting another person? Obviously, you know the answer. The defendant started it. The defendant ended it. Shiny object number 8. The video surveillance was taken by Cobb Theater employees, and all the way out of state it goes. And then it comes back in a box that no one opened until it had to be opened. All right, what does that shiny object mean? It means this. The DVRs from the Cobb Theater were taken, and they went all the way out of state, and then they came back in a box that was locked until someone had to open it. And now you get to see that very video. A video from the state and the video from the defense. And when you watch it, whatever the subtle differences are, it basically tells you what happened, because that's the silent witness. It did go, and it came back, and you watched it. End of story. It's a shiny object. Was it the best practice? Of course not. No one would argue it's the best practice, but it doesn't matter. Shiny object number 9. This is the testimony of Jennifer Shaw, Matt Reeves, and to some extent Joanna Turner. I want to be very clear on this point. Jennifer Shaw and Matt Reeves are absolutely not bad people. They are not bad people at all. They're good people. But in this particular case, for this time frame, testifying for the defendant, they're just not credible. Has nothing to do with who they are as people. They're just too biased because they're too close. Now let's talk about Jennifer Shaw's testimony. You remember she took the stand and she started crying. And I'm not making fun of the testimony. I just have to point out to you things that were just not right. So she takes the stand and she starts crying. And what's the first thing that she cries about? You know what? My dad asked me for the first time to help him. It was so shocking to me. He was deteriorating before my eyes. And she starts to cry. And this was over the kayak paddles. Now this is why cross-examination is good. You know, it's good for the state, and it's good for the defense, absolutely. It's the purpose of it. So what really came out after the tears about the deterioration of the defendant? What happened that day? The paddles, the kayak paddles, were actually stuck. And together, they twisted and pulled. Now, there's a lot of times that we went through probably some incredibly painstaking questions about physical ability. And if you were watching this trial and you just tuned in, you were probably like, what in the world are you all talking about? Well, you all know what we are talking about and why we are doing it. Because if there's the suggestion that the defendant shot and killed another person in a movie theater because he perceived himself as vulnerable, because he's a fragile egg that at any moment can break and be killed by either popcorn or even a fist, we got to address it. And that's the reason why we did. Did it seem like a lot of information? Sure. There's probably points in times where you were like, oh my God, we can skip these 7 hours. But it was important to bring up. So Jennifer Shaw, she's crying. I'm watching my father deteriorate before my eyes. But all that happened was the paddles were stuck, and together they were able to twist and pull, and boom, after 10 minutes together of doing that physical activity, they were able to pull the paddles apart. So was he deteriorating, or the paddles were just plain stuck? That's it. And on cross-examination, what did she tell you? Okay? Actions always speak louder than words. The defendant's words don't mean anything, meaning his statement to police and on the stand. His actions, what you observe and what other people say, mean everything. We saw a video, we're going to talk about Dr. Foley in a second, about all these x-rays and MRIs that were done like a year or so after this happened. What can the defendant do? What did Jennifer Shaw tell you the defendant can do? He can bike, right? Mountain bike, road bike. He can kayak, wiki-wachi. That's 3 or 4 hours of paddling, lots of turns. He would hunt, walks around the neighborhood, pulls a wagon, washes cars, pressure washes the house. Mows, you know in Florida that if you don't mow after a week, it's a jungle. Mows on his electric lawnmower. Washes cars, prunes, hedges, shoots sporting clays, shoots bows and arrows. The list went on and on and on. Just days before this shooting, what was he doing? Did he perceive himself as this vulnerable, fragile egg as he went 10 feet up into a tree to hunt? Walked at 100 yards each time, was able to sit in the car for long car rides, could drive up to North Carolina. And it seems kind of silly, but all those things take coordination. And if you have so much arthritis and you're deteriorating to that point, you can't do it because it's not the right picture being painted. That's why it's an incredible shiny object. Matthew Reeves, the only person to say it was nearly pitch black. Okay? They're not bad people. They're just not good witnesses in this case. Too close to home. Joanna Turner. Joanna Turner was called by the defense. Now, why didn't we call Joanna Turner? So think about this. Let's say there's a traffic crash. You got 5, 6, 7, 8 witnesses that tell you the light was red. And they don't know each other. And there's no reason they'd make it up. And then you have one person that says, you know what, I saw it and the light was green. What would your common sense tell you? It would tell you, you go with the red group. Joanna Turner, the shiny object Joanna Turner, is in the green group. For whatever reason, she perceived something that resembled a thermos. There's no thermos, but I specifically asked her. Now, her testimony, I'm sure you all recognize this. You use your own opinion. Maybe the last person that spoke to her, that would be the answer she'd say. But what she said was for sure it wasn't a cell phone. Now we're going to talk about the cell phone in a little bit. That's an incredibly shiny object in this case. So there was no thermos. Now let's just say there was a thermos and there's no evidence there was. What did she say? Well, at the time that I saw this flicking motion of what she perceived to be a thermos, she didn't even think anything violent was happening because she just went back to watch the preview. But that's why we didn't call Joanna Turner. Not that she intentionally was misleading anybody, she just didn't perceive it correctly. Why bring that evidence before you? That's why Joanna Turner wasn't called. Shiny object. Getting to the end of the shiny objects. Number 10. The testimony of Dr. Foley, Dr. Adams, and Dr. Cohen. Dr. Adams charges $450 an hour. You would remember him. He used to be the medical examiner at the Hillsborough County. Took the stand, went through an incredible amount of information. Basically, this was the testimony, I believe. Dr. Adams was speculating about all the possible events that could happen to the human body. At some future time, in some unknown way, with some unknown variable, hitting some part of the body might possibly, maybe, hurt somebody or kill them. That was basically his testimony. But here is really the telling moment with Dr. Adams. Now remember, of course, he's being paid. Now, I'm not telling you that people that come to testify shouldn't be paid. They got to pay their bills. Of course they should be paid. But you can consider that as part of their bias, right? So he's paid $450 an hour. Now think about this. What's important in this case? Well, we have eyewitness testimony and we have a video that Chad Olson did reach over. He should though, okay? And he grabbed the bag of popcorn. He flicked it, and as his hand was coming back, once that act was completed, he was shot and killed. Nothing was happening from that moment on. His hand was coming back from the popcorn, and that's when he was shot. So, the defense asked Dr. Adams, well, why don't we see stippling on his fingers? And the answer was, now you rely on your own recollection. Remember, what the attorneys say isn't evidence. I recall he said that because he had a fist, that's why there was no stippling. Well, Mr. Martin got up, and Mr. Martin was cross-examining him and said, well, at a previous time, didn't you say that it was because his fingers were outside the cone of the stippling? Oh, no, I didn't say that. And they went back and forth for a little bit. So finally, the document is shown to Dr. Adams, and what's he say? You know what? Now think about this. This is a very intelligent guy. He used to be the head of the medical examiner's office. I didn't understand Mr. Martin's question. So Mr. Martin said, well, today you said you didn't understand the question, and I asked it again. You didn't ask during that sworn statement for me to repeat it. You must have understood it. Again, he's not some bozo. He's a very intelligent person. Now, how is it then that he didn't understand such an important question? I mean, that's a really important question in this case. Well, once he's confronted with it, and he's like, well, gosh, I really can't say that. I mean, I had to have understood it. Then what did he say? The court reporter took it down wrong. Because she's got some motive to do that. I mean, you can mistype a word. You can misspell it. You can switch a word around, but you can't change the entire context of a statement. I mean, just Dr. Adams wasn't credible. Dr. Foley, we already talked about him. That's the x-rays. Actions speak louder than words. We're not going to go through all of Jennifer Shaw's testimony again. Dr. Cohen came in, and she told you that when people get older, they age, and their bodies change. And you know what? When people get older, they do age, and their bodies do change. In fact, the defendant was older, and his body changed. Doesn't mean a single thing. Let's say he was sitting in a theater with 2 broken legs and a rotator cuff injury, and someone threw popcorn on him. Oh, well, now that he's got 2 broken legs, he can shoot and kill somebody. That totally makes sense. You know what? His back's hurting really bad. He's got a herniated disc. Popcorn goes on him. Yep, absolutely. We can kill him. Sure, you get older, you can just kill people. But actions speak louder than words. All of that testimony are shiny objects. And she talked about people perceiving themselves as vulnerable, and if they perceive themselves as vulnerable, that's why they may do a certain action. Is the testimony and the evidence and the video in this case, does it demonstrate that the defendant perceived himself as vulnerable? Absolutely not. Did he try to de-escalate things because he felt vulnerable? He leaned in twice to Chad Olson. He instigated. He started. Did he perceive his health as deteriorating? I mean, all these little things we talked about seem so silly. And I almost hate to bring them up. But the week before, he's hunting and going up in trees. That day, he drives. It sounds silly, but his wife could have driven. Could have dropped him off at the front if he was such and such poor shape that day. They chose the back row, for crying out loud, all the way in the middle. If your back hurts, you're going to sit at the aisle because you don't want to walk around people. We all know how uncomfortable that is. And yes, of course he used the wall for balance. No one wants to step on people's toes. If you have such concerns for your safety and you perceive yourself as vulnerable, you don't do a single thing the defendant did in this case. And it just goes along with his statement. It's so untrue. And that's why you keep going back to, it sounds sensationalized, but he started it, he ended it, and he killed someone over a popcorn toss. The last shiny object, and then we're going to talk about the facts of the case with the law. Cell phone DNA. The more you talk about it, the louder you talk about it, just makes it shinier. Look over here, don't look over here. Why is there no DNA on that cell phone? I mean, obviously you all know why. There is no way, ever, in any fact pattern...
Judge, I'm going to object. That's a misstatement of the evidence. There is DNA on that phone.
Okay, I'll rephrase.
Thank you.
There is DNA that is uninterpretable on that phone. It doesn't matter. It literally doesn't matter. There is no way ever that phone was used in this case against the defendant. Ever. Not a single witness sees this phone event take place. And his wife, who's sitting next to him, do you think that she would have seen a violent attack with a cell phone happen if she's sitting right next to him? Oh, I closed my eyes. Come on, really? All the people in the theater didn't see it. The silent witness video doesn't see it. The defendant has no injuries. How in the world is that even remotely possible? Oh, that's right. His left eyelid had a red mark behind his glasses. Now, the only reason I had his glasses passed around is just to show you that the hard part on the nose is there, like on most glasses, and if he was hit in the face, he'd have a mark. It'd cut him. If it was that hard that he literally thought he was going to die at some point because that's how violent Chad Olson was. The most easily bruisable person, because he testified he's easily bruisable. Jennifer Shaw testified he's easily bruisable. A phone is thrown at him. Now he changed his story. First he said he was hit with a fist. Maybe the hand had a phone in it. Now the phone was thrown at him. This phone never, ever touched him in that manner. Ever. Ever. And if you remember, there's so much information that comes about sometimes. You almost have to be like an encyclopedia of knowledge. If you remember back when he was testifying, he said something really interesting if you caught it. Okay? He said, because you couldn't see Chad Olson in the picture frame, that he was too far away from him when he threw that phone. Very interesting that he said that. But here's something else. Remember, he changed his story. Because in the post-Miranda statement, when Chad Olson jumped up, the popcorn fell. So based on his statement, and you have to listen to the whole thing because he talks about it and then they go over it. He says the popcorn went by the wayside almost immediately. Which means when you see that video and Chad Olson standing up, we shouldn't see the popcorn, or we should see it fall. But what we really see is popcorn being tossed and then a shot takes place. That's how we know with 100% certainty the defendant wasn't being truthful. But what's he say? He says that when Chad Olson stands up and the popcorn falls by the wayside, it's at that time this attack happens that's not seen on video or by anybody in the theater, including his wife. And he says at that time is when he was hit by the phone. But he doesn't really know, because when he looked down he saw the phone, so he just put two and two together. But on the stand he talks about this phone attack happening 8 seconds before. How in the world is that? He changed his story. Now we have two unreasonable stories I submit to you. Self-serving stories don't equal self-defense. If he was hit by a phone, or even if he was hit by a fist from a 6'2" person who's raging mad, how in the world does he not have an injury other than a left eyelid behind glasses? You know why? Because it didn't happen. He was explosive and he was mad about the popcorn. That's what this case is. He started it and he ended it. Those are the shiny objects. So let's talk about what this case is. What's the credible evidence? You take those shiny objects, you put them away. What's the credible evidence in this case? We know that the Olsons came to the theater on a Monday. They dropped their daughter off at daycare. They sit in the theater, second and back, last row. We know at some point one of them wanted another piece of candy or something. Chad Olson goes out to the concession stand and comes back. I believe if you look at the video, it looks like they're there first. It doesn't matter. Then the defendant and his wife sit behind them. He has his phone. He's not talking. He's not conducting business. The light's on. Previews come on. Now, according to Jane Roy, who doesn't know anybody and would have no reason to come in here, say anything other than what she observed, she said almost immediately after the cell phone message came on, boom, here comes the defendant. Now, it's the previews. I'm not saying he should have his cell phone on. Certainly doesn't justify what happened to him. And do you really believe that this cell phone light was so incredibly bright that it was ruining his movie experience for the previews? Anyway, that's not even a big issue whatsoever. So what happens? The defendant leans in. Now, I submit to you, based on all the evidence that you've heard, he does not lean in and say, "Sir, I'd really appreciate it if you would just turn your cell phone off." No. Not the guy that is into the adrenaline and the danger and likes to be in control. Nicole Olson and Jane Roy, who don't know each other, testified about the defendant's demeanor. He leaned in and he was telling Chad to turn his phone off. He did it twice. Now, would a person who perceives himself as vulnerable, "Oh, yeah, I don't want, I got a lot of things going on. I don't want to really get into any roughshod, and I can always de-escalate it with my background training experience." Does that guy get up right away to go to tell the manager? No, he's got to lean in a second time and tell him he's going to the manager. Why do you have to tell someone you're going to the manager? Get up and go to the manager. But he wants Chad Olson to know. So he leans in and tells him. So he gets up, he goes. Now, what does Jane Roy say? He's mumbling to himself. He appears agitated. He appears angry. And this is when it starts to begin, when we're talking about ill will, hatred, spite, or evil intent. And it culminates, whatever how many minutes later it is. I don't know if it's 3, 4, 5, it doesn't matter. But it culminates after the popcorn when he explodes, "Throw popcorn in my face." This is when it starts. Because Chad Olson, should he have turned his phone off? Sure. But he's like, "Look, man, just leave me alone. Mind your own business. Do what you got to do." So he gets up and he goes to the manager. Jane Roy testified that he appeared agitated. Now, we have a video that's in evidence. You watch it. I'm not saying that he was at the desk yelling and screaming. Witnesses came in and said, okay, he was there and he was talking. Now, these witnesses testified, I think her name was Simpson and maybe Mr. Peck, that, well, he was telling us about what happened. He was polite. But when you watch his mannerisms, he could very well be polite, but he was certainly agitated. And remember something that Vivian Reeves testified to. These are just little nuggets. If you don't recall it this way, absolutely do not just take it from me. You have to rely on your own memory. But she said she was kind of ticked off. Now, he goes and he tells the manager. Now, he doesn't tell the manager, "This guy's telling me to F off," nothing like that. But a guy that's trained in de-escalation, as to not be an instigator, what could he have done? He could have stayed and waited for the manager to go. But when I asked him that question on cross, what did he say? "Oh, the manager told me to go back." He still could have stayed there. He could have waited for the manager. Just because the manager tells him to go back, all of a sudden, "Oh yeah, I'll just..." If he was really concerned, could have waited for the manager. So he goes back into the theater. Now, this is where I submit he was being truthful. He goes back into the theater, and what happens? Chad Olson, either he put it away or he turned it off. It doesn't matter. It truly doesn't matter. The point being this. The issue has been resolved. Everyone can enjoy their movie experience. So what does the defendant do? The person that's trained in de-escalation, does he sit back down in his seat and let it go? What's he do? He initiates again. He pokes him. "I see you put your phone away. I wouldn't have had to go telling you." Why in the world does he have to say that? Because he's the alpha male. He wants to let him know. Because he's used to being in control. It's like getting in the last word with a kid. It's spiteful. He could have just sat right down. So Chad Olson, what's he do? Well, as the defendant states, because there are some gems in there, okay? The defendant states that he then turns around in his seat. And it's a big difference. In versus jumping up. Now, the reason that I gave those photos to you, the defense photos, was for you to see with your own eyes that he was, in fact, turning around in his seat to have this conversation. And who's that consistent with? Derek Friedoff. Remember what Derek Friedoff's testimony was? Going back before the manager, Derek Friedoff testified he heard bickering. Bickering's an interesting word to choose. When your kids bicker, you know your kids are kind of like back and forth. They're not having a friendly conversation. There's bickering. So when the defendant wants you to believe, sir, I'd really like for you to turn your phone off. That's not what Derek Friedoff testified to. And what did Derek Friedoff say? When he went to the manager, everything settled down. Homeostasis, everything's fine. And when does the bickering start up again? When who is reintroduced into the equation? The great instigator. And now it's back up again. Because he started it and he ended it. So Chad Olson turns around in his seat, and I gave you those pictures to look at because had he been standing, he would have looked the way that he looked at the time that he was shot, at the time that the popcorn came into play. He's standing there, he turned around in his seat before. Now remember, Derek Friedoff told you, and even the defendant said this, at no time was Chad Olson turning around prior to the popcorn and initiating a conversation with the defendant. He was always looking forward. He was the one out of the two that was trying to de-escalate it. Now, he could have remained quiet, but I submit to you the defendant would have just kept going and going and going. But he's looking forward. Leave me alone, sir. Leave me alone. If anybody, Chad Olson is trying to de-escalate the situation from the person that's instigating it. So what happens? The credible testimony is this, that at some point in time, he does get up. And at some point in time, it's clear as day what he does. He leans over and he grabs the popcorn and he flicks it on him. Is it reasonable to believe that this defendant, with all his background, training experience, and his karate experience that we're going to absolutely address in a little bit, felt that when that popcorn bag was grabbed from him, he was going to die? Because that's what some of the instruction for the law of self-defense is. Did he reasonably believe he was going to die right then and there? There is no way in the world. Or did he reasonably believe that he was about to suffer great bodily harm? Now, there may be an argument made, well, he didn't know that he was going for the popcorn. He just saw a hand coming at him. We're going to address that whole thing right now. First of all, we know it's about the popcorn because that's the statement. Don't lose fact of that. Okay? If you hear, a hand's coming at him, he reasonably believes because a hand was coming at him. No, he killed them because of the popcorn, because he said that right after the shooting. Throw popcorn in my face. He knew what happened. It's not just a hand's coming towards him. He knew what it was. And when you watch the video, you see the popcorn and you see from the hip the shot. That's this case. Let's say you want to make the argument that he didn't know about the popcorn. You'd have to disbelieve Derek Friedoff, Mark Turner, Charles Cummings. And let's say you wanted to make the argument he saw a hand coming at him. Did he reasonably believe that that hand was going to kill him? Absolutely not. Did he reasonably believe that that hand was going to punch him so hard that his orbital bone was going to fracture and go into his brain? Come on, no, that's unreasonable. And you can't shoot somebody for punching you. You can't. Oh, he's vulnerable. That's what No, he's not. He's an instigator. He's not this vulnerable person. Okay, so he's sore. You can't kill anybody for that. So Chad Olson stands up. Now, there's a lot of dynamics going on. He grabs the popcorn, he tosses it, he's shot and killed. In that time frame, Nicole Olson's standing up, and she's just like, honey, come on. Now, the defendant wants you to believe there's this royal battle between Chad and Nicole. How is it no one sees this royal battle? How is it? How's that? How does Vivian Reeves, who's right there, not see this battle? If you want to say, well, Nicole Olson's saying there's no battle because she's got an interest in the case, how does Vivian Reeves not see a battle right in front of her eyes? How does no one hear or see this life and death struggle? Because remember, I asked him on the stand, was this a life and death struggle? Oh yeah, this was a life and death struggle. In my entire career, I've never seen anything like this. Come on. So he shoots and he kills Chad Olson and basically shoots off Nicole Olson's finger. And we know why. So what's the law in this case? What was the defendant charged with? There's a lot of laws that apply to this case. At first glance, it might seem confusing. It's going to be like a law school class. And we're going to talk about it. So, the defendant has been charged with second-degree murder. When you hear murder in the second degree, it's the same exact crime. For whatever reason, in the jury instructions, they flip them around. It's the same crime. He's also been charged with the crime of aggravated battery. That's for shooting Nicole Olson. Now, at the beginning of the instruction for second-degree murder, you're going to hear about this. This is called Introduction to Homicide. This is either going to work or it's not going to work. We're going to say that it's not going to work right here. It'll work. That's all right. I'll give you a second. All right. So let's use this one just for now. Okay. Don't need that other one. All right. So Introduction to Homicide. Make sure everybody can see this. If I put this right here, can everybody see it? Can everybody see this now? Okay. All right. Introduction to Homicide. So this is the instruction that you're going to hear. In this case, Curtis Reeves is accused of murder in the second degree. Murder in the second degree includes the lesser crime of manslaughter, which we're going to talk about, which is unlawful. A killing that is excusable or was committed by the justifiable use of deadly force is lawful. If you find Chad Olson was killed by Curtis Reeves, you will then consider the circumstances surrounding the killing and deciding if the killing was murder in the second degree or manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. So let's talk about justifiable homicide. This is the instruction. The killing of a human being is justifiable homicide and lawful if necessarily done. So let's talk about that. Every word in jury instructions is important. Okay? Necessarily is very important in this instruction. Meaning, was it absolutely necessary and it makes sense? Because if you're taking a human life, you got to be 100% sure. There's no gray area when you're taking another person's life. It's justifiable homicide and lawful if necessarily done while resisting an attempt to murder. Okay, we'll just throw that one out. We know there's no attempt to murder the defendant. While resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house. All right, so this last sentence here is about in the home, doesn't apply, we're in a movie theater. Okay? So was it necessary while resisting an attempt to commit a felony? All right, so let's talk about that. And that's why I'm talking to you about necessary. Okay? We're going to talk about this in just a second. I just want you to keep that in mind. Okay? Is it necessary? That's justifiable homicide. Then you learn about excusable homicide. Now, here's excusable homicide. Can everybody see that? The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. Now, the reason that when I started my cross-examination with the defendant, I asked is, was this an accidental shooting or did you intentionally shoot him? You know, you might, well, why would he ask that question? This is exactly why, just to cover. Okay? This is not an accidental shooting. This is an intentional shooting. It's just that he's saying he intentionally shot him and it was lawful self-defense. Everyone understand what I'm saying? This is not an accidental shooting. It's an intentional shooting. He's just saying he had a defense to it, which I submit to you obviously wasn't very credible. All right, everyone understand that? That's what this means. When the killing is committed by accident and misfortune in doing a lawful act. So let's say someone's cleaning their gun and the safety's off and the table leg breaks and the gun falls and someone dies because the gun went off. That is an accident and misfortune. The defendant intentionally shot Chad Olson, so none of these apply. By law, though, you might say, well, why are we hearing about these then? Because the law requires that you hear this. That's why you're hearing it. The law requires it. When the killing occurs by accident, doesn't, number 2. Number 3, committed by accident, and it talks about a dangerous weapon not being used, okay? Accident, accident, accident. This whole instruction doesn't apply, okay? Number 3 talks about a dangerous weapon, okay? And then there's a definition. A firearm is a dangerous weapon. So the whole excusable homicide doesn't apply to this case. Again, the law requires you hear it. That's why I'm telling you about it. So what's the crime of murder in the second degree? So here, remember we were talking about at the beginning of closing arguments that crimes are built of elements. And when you go to school, the way people explain it are their building blocks. And we have to prove each of these elements to you for the crime. The way it works is this. There's a highest crime that's charged. The highest crime that we've charged in this case is called murder in the second degree or second degree murder. Again, it's interchangeable. If and only if you feel we have not proven that crime beyond a reasonable doubt, do you go to the next one that we're going to talk about, which is right here, manslaughter. Okay? We're going to talk about that one in a second. This is the main crime that's charged. When you deliberate, you start with this one. You take all the credible evidence, and you take those facts and you go down the line. Okay, number 1, Chad Olson is dead. Obviously we have that. So we know that element's satisfied. Okay? So that's how you analyze a case as a juror. So let's talk about what second degree murder is. Element number 1, do we prove that? Yes. Element number 2 and element number 3 go together, and that's basically what the defense is in this case. Element number 2, the death was caused by the criminal act of Curtis Reeves. Number 3, there was an unlawful killing of Chad Olson by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. Then there's definitions. An act is imminently dangerous to another and demonstrating a depraved mind if it's an act or series of acts, and then there's more things. So you take all the credible facts and you apply them to the elements. Would a person of ordinary judgment, would that person know it's reasonably certain the act was an act reasonably certain to kill or do serious bodily injury? Okay, if you shoot someone basically in the chest, obviously a person of ordinary judgment would know that act would kill somebody or seriously injure them. Number 2, we're going to save for a minute. Number 3, the act, which is the shooting, right? That's the act. Okay? So was the shooting, would a person with ordinary judgment know shooting person in the chest could result in death? Yes, that's number 1. Number 3, is shooting someone in the chest a nature, is that an act that itself indicates indifference to human life? Absolutely. If you shoot someone with a firearm in the chest, obviously it's an act that's indifference to life. The one that we need to discuss is that this act, the act of shooting, was the defendant shooting Chad Olson, an act done from ill will, hatred, spite, or evil intent. Now that's the issue for second degree murder. So in order to determine whether or not when he shot him he was acting from a place of ill will, hatred, spite, or evil intent, that's when you go back to the totality of circumstances that we had just been discussing. In a very summarized fashion, it's the cell phone light bothering him. That's the beginning. The interaction, the instigation to have that cell phone turned off. When it's not, to get up to go tell the manager, to come back and reinitiate the contact. That's all evidence of ill will, hatred, spite, or evil intent. And when he takes that firearm out and he puts it to his side, when he slides it up from that pocket, because I submit to you that's exactly what happened. And when that popcorn went on him, he lunges. Again, you have to watch that video because it's very powerful to see. It's like he's saying, and that action in and of itself, when you look at everything, was done from ill will, hatred, spite, or evil intent. Coupled with the statement, However it was worded from the witnesses, the impact of it is throw popcorn at me. Throw popcorn in my face. In other words, who are you to throw popcorn at me? And he lunges forward and he kills Chad Olson. Do all those acts show you that when he shot Chad Olson, that he did it with ill will, hatred, spite, or evil intent? And I submit to you, it does. He started it, he ended it, and it was a man that was killed over a popcorn toss. Now, if you do not feel that we have proven the case beyond a reasonable doubt for murder in the second degree, then and only then do you get to manslaughter. Now, one other thing that I want to bring up about second degree murder. On the verdict form, you're going to see what are called interrogatories. So on the verdict form, there's questions after the crime. So let's say that you believe, and I submit to you we've proven that case beyond a reasonable doubt. You would check off that the defendant is guilty of murder in the second degree. Then there's 3 questions, and you would only check one of them. And it will say, did the defendant, I'm paraphrasing a little bit, did the defendant possess a firearm? The next one would say something to the effect of, did the defendant possess and discharge a firearm? And then the third one would say, did the defendant possess, discharge, and cause great bodily harm or death? Now, obviously, that's what this case is about, and you would check the third question. By law, you have to have all these things done. That's why I'm telling you about that. All right, so if you feel as though, and I submit we have proven that case beyond a reasonable doubt, but if you feel as though we haven't, the next crime is called a lesser crime. It's called manslaughter. This is the law of manslaughter. Element number 1, Chad Olson is dead. Obviously, that's been proven. Then you could do 2A or 2B. Curtis Reeves intentionally committed an act. Did he intentionally shoot Chad Olson? Yes. That caused the death of Chad Olson? Yes. You really don't have to go to 2B. If you go to 2B, you have to read, there's a long instruction. I'm not going to read it to you. You're going to have it in your jury packet, or Judge Barkel's going to read it to you. But really, 1 and 2A is fine. So what's the main difference between murder in the second degree and manslaughter? Whether or not someone acted with ill will, hatred, spite, or evil intent. That's the only difference. So if you find that the defendant shot and killed Chad Olson, but it just wasn't legally justified, it was not a lawful shoot, it was a bad shoot, that would be the crime of manslaughter. Murder in the second degree is if based on the totality of circumstances, ill will, hatred, spite, or evil intent. So manslaughter is a lesser included crime. If you do not feel as though we've proven second degree murder beyond a reasonable doubt, there can absolutely be no doubt. I submit there isn't for murder in the second degree, but it's certainly manslaughter. This was not a justified shooting. Absolutely 100% not a justified shooting. That would be manslaughter. Under manslaughter, there would be 1 interrogatory, and it would just say something to the effect of, was a firearm used, or something like that. The other crime that the defendant's been charged with is the crime called aggravated battery. Okay, and again, you're going to hear all these instructions. Aggravated battery is basically this: that the defendant intentionally touched or struck Nicole Olson against her will. Okay? And it sounds silly, but this, you just have to bear with me for the explanation. He shot her, so obviously he intentionally touched or struck her against her will. You don't have to use your own body if a shooting counts, because he was the mechanism behind touching or striking her against her will. In committing the battery, did he intentionally and knowingly cause great bodily harm to her? Permanent disfigurement or permanent disability. Well, her finger is basically shot off. You saw the photographs. Or, number 1, did he intentionally touch or strike her against her will? Yes. Number 2, in committing the battery, did he use a deadly weapon? That's probably maybe the easier way. Yes, he used a firearm. Okay, a weapon's a deadly weapon if it's used in a way likely to cause death or great bodily harm. That's the definition you'll get. Obviously a firearm. Okay, so that's aggravated battery for shooting Nicole when she had her hand up. Now, you think, well, How could that be? Well, there's a law called transferred intent. And here's the law for transferred intent. Basically, if a person intends to shoot a person, so if the defendant intends to shoot Chad Olson, and in the process shoots a different person, Nicole Olson, the law transfers the intent to shoot the intended person, Chad Olson, to any person who was actually shot. So it sounds kind of circular, but because he intended to shoot Chad, and Nicole had her hand up, and he shot Nicole, the intent gets transferred to her. Now, the caveat to that is if you find that he was acting in self-defense, then it doesn't apply. Okay? That would be the caveat to that. So what's this case really about? Okay? The defendant is claiming that he lawfully acted in self-defense, that there was a justifiable use of deadly force. This instruction is a little bit complicated. I'm going to go through it just to explain what it states. An issue in this case is whether Curtis Reeves acted in self-defense. It's a defense to the crimes of both second-degree murder and manslaughter, if the death of Chad Olson resulted from the justifiable use of deadly force. And deadly force, of course, means what happened here, the defendant shooting him with a firearm in the chest. Now that reminds me of something that I need to address. Real quickly, at the very bottom on my board, and you're going to get this instruction, we do not have to prove for second-degree murder that the defendant intended to kill him, just that he intended to shoot him. And the fact that he died is fine, if that makes sense. Okay? Not that, him dying, of course, is not being fine. But we don't have to prove that when he shot him, he meant to kill him. We just have to prove that he shot him and he died. Okay? That's what this means. In order to convict a second-degree murder, it's not necessary for the state to prove the defendant had intent to cause death. Just that he shot him and he killed him. Okay? Just a little teeny distinction. All right. Back to justifiable use of deadly force. Again, every word in here is incredibly important. The use of deadly force is justified if Curtis Reeves reasonably believed. So remember, in the first instruction, was it necessary to kill Chad Olson? Absolutely not. Here, did Curtis Reeves reasonably believe that the force was necessary? So you kind of paraphrase that. The use of deadly force is justifiable if Curtis Reeves reasonably believed that shooting and killing Chad Olson was necessary to prevent his imminent death or great bodily harm to himself, while resisting an attempt to commit the felony offense of battery on a person 65 years of age or older. All right, so that seems like that's like a loaded paragraph. Let's break it down, okay? There is a crime called battery, okay, and we talked about it. I was cross-examining the defendant about it. Battery is when you intentionally touch or strike someone against their will. Bob is walking down the street, he punches Joe. That's a battery. He slaps Joe, pushes him, trips him, throws popcorn on him, throws soda on him. That's a battery. That's a misdemeanor crime. Now, if someone is over the age of 65, it becomes a felony only because of the age. That's the only difference, which is why you're hearing about this crime. Battery over 65. So Bob and Joe are walking down the street. Joe is now 66, 69, let's say 71. And Bob pushes Joe or punches Joe. It's a felony, but because he was over 65. That's it. So, looking back at this instruction, the use of deadly force is justifiable if the defendant reasonably believed that shooting and killing Chad Olson was necessary to prevent imminent, meaning right then. Would it be reasonable for the defendant to think, at that time sitting in the theater, with the lighting condition as they were, where people can see, people can hear, is it reasonable to believe, would a reasonably cautious and prudent person believe they were about to die? Absolutely not. So shooting and killing Chad Olson wasn't necessary to prevent imminent death or great bodily harm to himself. Okay, great bodily harm. There's a definition for great bodily harm. It doesn't include bruising. It doesn't even include moderate harm. It is what it is. Great bodily harm. Would a reasonably cautious and prudent person in the defendant's position, with all this training about de-escalation tactics, would a reasonably cautious and prudent person believe that as he sat there and the hand came across and grabbed that popcorn, that he was about to suffer great bodily harm? No. This is not a justified killing. Absolutely not. Now remember, don't lose fact of what the sentence was that he said, because it's not just a hand coming towards him. He knew popcorn was thrown at him. He knew that bag was grabbed. And when you watch the video, you can see it. The bag, the popcorn, and he shoots. And he lunges forward. And he says, don't throw popcorn at him. He knows it. Not just a hand coming in. That's so important. But again, let's just say for some reason you want to discount that. A hand coming in does not lead a reasonable person to believe they are about to just be beaten to a pulp. It's simply not true. And he started it. And this felony offensive battery is only because of his age. That's it. A person is justified in using deadly force if he reasonably believes that such force is necessary to prevent imminent death. We already talked about that. Or great bodily harm. We talked about that. Or the imminent commission of, there should be a Y here, but imminent commission of aggravated battery against himself or another. So let's talk about that. We got to break that one down. Did he have to kill Chad because he felt he was about to die? The answer we've already covered is no. Did he kill Chad because he thought he was about to be beaten to a bloody pulp by a hand just coming in? Again, don't focus on that. He says the popcorn, he knows about the popcorn. So none of this applies. So let's talk about where the imminent commission, meaning about to happen. That's what it means. Imminent commission of this crime. Was he about to have an aggravated battery committed against him? Okay? So what's the evidence in this case? You really got to analyze this. The evidence is this. He reaches in and he grabs the popcorn. He brings it back, he throws it. His hand is on his way back. Nicole Olson has her hand coming up. He's killed. Is there anything that is about to happen? No, because he had already just completed the act. In fact, he wasn't even so far back to start anything because he was shot for throwing the popcorn. Did he shoot someone because he was about to be attacked? No, the popcorn had already been thrown and that event was over. And you can see it in the video as well. He throws it and as his hand's coming back, that's when he's shot and killed. There's no imminent commission of anything else. Now, let's say that the fact pattern was that he throws the popcorn and he stands there for a couple minutes and now he starts to jump over the seat and attack him. That would be a fact pattern that would apply here for this instruction. But in this case, the video shows you that he had thrown the popcorn, his hand was coming back, and that's when he was killed. And it's all about the popcorn. That's why the defendant is not justified in killing Chad Olson. That's what these instructions say. Now let's look at this paragraph because it's extremely important as well. In deciding whether Curtis Reeves was justified in the use of deadly force, You must judge him by the circumstances by which he was surrounded at the time the force was used, meaning the shooting. At the time of the shooting, what were the circumstances? Okay? I know I'm repeating it a lot, but it's so important. At the time that the defendant shot and killed Chad, he had already thrown popcorn on him, his hand was coming back, and he shot him because of the popcorn. That's the circumstances. So at the time he shot him, what was happening? His hand was coming away. And he knew it was about the popcorn. Despite what he says in any of his statements, both of them, that actually contradict each other, that's not believable. Those are the facts. Now, the danger facing Curtis Reeves need not have been actual. Now, I blew this particular part of the instruction up because it's really important as well. In deciding whether Curtis Reeves was justified in the use of deadly force, you must judge him by the circumstances. That's what we just discussed. The danger facing Curtis Reeves need not have been actual. However, this is what applies. It need not have been actual. However, to justify the use of deadly force. So, the danger facing Curtis Reeves need not have been actual, but in order for him to shoot and kill Chad Olson, the appearance of danger must have been so real that a reasonably cautious and prudent person under those circumstances would feel that the only way to avoid what happened was to kill Chad Olson. Okay? Now, what would be an example of this? Because it's not this fact pattern. This fact pattern doesn't even come close to this. Okay? The appearance of danger must have been so real. Okay? The defendant is sitting in his chair. He's just instigated this person. He reaches over and grabs the popcorn, and now it's coming back. That's the circumstances. That's it. Okay? There's no imminent commission of anything. He had just completed throwing the popcorn. Again, we know it's about the popcorn from the statement. But what would be an example of this? Okay? Because it's very important not to be confused by what this means. Here is an example of how the appearance of danger must be so real that a reasonably cautious and prudent person would think they have to kill another human being. Two people get in a road rage incident. They pull over to the side of the road. Driver 1 gets out. Driver 2 gets out. Driver 1 starts making some threats to driver 2. I'm going to kill you, you mother, yeah, I'm going to kill you. Okay? Now in this case, there's no threats like that. Now the defendant wants you to believe there's threats. Remember, not a single person hears any of these threats because it didn't happen. Driver 1 gets out, driver 2 gets out. Driver 1 is threatening to kill driver 2. Driver 1 suddenly turns around, runs back to his car, reaches in, grabs his wallet, turns around with this black object. Driver 2 is like, oh my God, this guy just said he's going to kill me. He's turning around with a black object. I'm going to have to kill him. Bam! The appearance of danger was so real that a reasonably cautious and prudent person under those circumstances would realize that shot had to be taken. That would be a perfect textbook example of what this means. Because he was just threatened. Someone was going to kill him. The guy turns around and runs back to his car. He grabs a black object. Now, could that wallet have killed driver number 2? Of course it couldn't. But the appearance of danger was so real. He threatened to kill him. He ran to his car. He grabbed the black object, and he suddenly turned around. Any reasonable person under those circumstances would say, yeah, I can see how that guy would think that a gun was just taken out. Obviously, that wallet couldn't kill him, but I would have shot him too. Textbook example of what this phrase means. It does not mean that because Curtis Reeves, in his mind, believed this imaginary attack happened, that he's justified. Because a reasonably cautious and prudent person in his situation, sitting there, having popcorn just dumped on his lap, would not believe you have to take another human being's life at that moment. It even sounds crazy to mention it out loud, but that's the fact pattern in this case. This instruction does not justify killing Chad Olson. Even if he reasonably believed that he didn't, I submit to you, he made up a story in the cruiser to cover his tracks, not realizing so many people saw it, and not realizing the silent witness video captured the whole thing. He didn't reasonably believe for a second his life was in danger. And that's why he changed his story from his post-Miranda statement. Because think about what he did. Think about this. He went from 1 attack to 2. Because what does he get by changing his testimony to 2 attacks? This reasonable belief that something's happening. The day of the shooting, again, I submit to you this story is not even credible. But he says that he was attacked after the popcorn fell, completely dispelled by every witness and completely dispelled by the video. But during the trial, he changes his story to say, you know what happened? And it's funny because I asked him, you remember, I said, why? How in the world do you get these 2 stories? He's like, I don't know. How do you not know when you kill another human being? So why does he change his story? Because he has to add an attack. Because he knows that post-Miranda statement is so bad for him. So he changes his testimony and he indicates this. He states, no. The popcorn didn't go to the wayside. And I wasn't attacked with him virtually on top of me. Remember he's saying all that? Remember his first statement? So what happens is I'm sitting there and he jumps up and the popcorn falls by the wayside almost immediately. And now he's coming over on top of me. And I'm back in my chair. Well, that's when he was getting the gun in reality. But let's go with his statement. I'm back in my chair leaning back and I got my left hand out. And I'm yelling, no, and whoa. And I'm touching his chest or his shoulders because remember his own words. He's virtually on top of me. He's in my lap. Well, on the stand, he's like, no, I meant leaning. What? The defense attorney is talking about minutia words to witnesses. He's changing from virtually on top of me and in my lap to leaning? Are you kidding me? How many reports do you think he's written in his life where it's important to be truthful and accurate? Come on. Because he's painting a picture that he had to kill him, not knowing there's a video out there to disprove it. So he says he's got his left arm out and he's touching his chest or his shoulders. And I gotta kill him. I can't believe I didn't shoot my hand because my left hand's out as I'm fighting him off in this life or death struggle. That's truly not happening. And we know that didn't happen for several reasons. One, there's no stippling on his left hand. Everyone that was shot, everyone that was in front of his gun has stippling. Nicole and Chad. How is it that he doesn't have stippling on his left hand? Well, possibly it's the same reason why he doesn't have an injury from a phone that was thrown at him. He's not some magic person. It's because it didn't happen. But you don't even have to look at that common sense argument. You just have to watch the video. I played it slowly and rocked it back and forth like you can do it in the jury room to show you that what actually happened is as he's shooting out from the hip, when the popcorn hits him, because he's mad, he takes that left hand, you can clearly see it in the video if you watch it, and based on his muscle memory, he slaps it against him so he doesn't shoot his hand. So when he's like, oh my God, I'm so surprised I didn't shoot my hand, watch that video. His left hand goes up, and based on his muscle memory, he immediately brings it to his chest. And that's exactly what happened here. He intentionally killed Chad Olson because he was mad. You see it plain as day on the video. In court, he changes his story, and what's he say? In court, he says, well, I came back from the manager and he was staring at me. Now, why was that important? Because he wants to be like, I'm the great de-escalator. To calm him down, I wanted to tell him everything's all right. But he didn't tell that to Detective Proctor, because to Detective Proctor he says, I reinitiated, because that's truly what happened. Then, on the stand, he gives this version. Well, I came back from the manager, and that's when I was attacked, a full 5, 6, 7, 8, whatever the number is, seconds before. So when I saw his hand coming towards me, that's why I realized I had to kill him. But we know for a fact that didn't happen. Number one, why would he change his story? Number two, what's this first attack that happened 8 seconds before? Well, first he says that he's hit with a fist. Then he says it's a fist with a phone in it. And finally on the stand, he threw the phone at me from some distance. Because I demonstrated on the video that he wasn't even in the camera when it happened. Let's just go to the next illogical thing. How in the world was it that he's able to be hit with a phone and not be injured? How in the world is he hit with a phone and his wife, who's sitting right next to him, doesn't see it happen? How in the world does not a single person in the theater see that happen? How in the world is it not captured on video? How in the world does he get hit with an object so hard that he continues to go forward and not react with his hands? That's because he's trained in karate. That's what his testimony was. Not even making that up. No human in the world gets hit with a phone that hard and doesn't yell, ow, oh my God, I can't believe this, and go for their head. It never happened. None of it happened. What happened was he killed Chad Olson for no reason other than the fact he was mad. And if you don't believe that's the reason, he unlawfully killed him, and it's manslaughter. I'm going to show you 2 pictures. I'm going to show you 2 pictures, and these pictures tell you the story. In my left hand, this is the defendant, Curtis Reeves. You may see that his left eyelid is red. From all accounts, people testify that he was touching his face afterwards. The detective indicated that he was rubbing his eye. This is Chad Olson's picture. Did this person reasonably believe this was necessary in this case and in this fact pattern? The defendant is guilty of either murder in the 2nd degree or of manslaughter, and he's guilty of aggravated battery as well.
Thank you, Mr. Rosenwasser. Ladies and gentlemen, let's take 15-minute recess and remember my instructions during the break, please.
All rise, we're in recess for 15 minutes.
Thank you. All right, let's take a recess. Are we set? Ready to go? What you gonna be using that for? Various,
A bunch of things. Jury instructions, photos, videos, a lot of things.
just show them to me if you can, or tell me what you're referring to. I should have it.
They're all the exhibits that were in evidence.
All right. I just wanted to sit back here and not over there. All right. Well, we'll cross that bridge when we get to it. Go ahead and bring them in. I did tell the jury, because hang on one sec.
Let's give them just a few minutes.
Yeah. Because of the long time we're going to go, I told them to tell the jurors that they can have snacks in there.
Judgment may be a little bit less than 3 hours.
Okay.
I calculated.
Okay.
2.5.
Okay. I anticipated that, and it is what it is. Yeah, there we go. Okay, ready? Did you,
I think they had asked them
what,
7 minutes.
who, the jurors?
Yeah.
Oh, okay. Yeah.
Jury, you're in the courtroom, you're off.
All righty.
Jury may be seated. All jurors are present and accounted for, Your Honor.
Thank you, Deputy. Ladies and gentlemen, were you all able to abide by my instructions during the recess? All right, very good. We'll go ahead and get started. Mr. Escobar?
Thank you, Your Honor. Counsel.
I better reposition.
You don't judge a person until you have walked a mile in their shoes. It's a very wise old saying, and one that actually is embodied in the laws of self-defense, not only in the state of Florida, but in this country. The Constitution of our great country embodies the right and the law of being able to defend yourself. There's a great wisdom in our laws, both nationally and here locally. A great wisdom. That wisdom in the law of self-defense starts with a term called perception. You're going to work with that term throughout your deliberations in this case. Because the law protects that reasonable perception. Reasonable perception. You have to walk in the shoes of someone before you judge them. You've got to walk a mile. The law of self-defense requires us all to judge the reasonableness of that perception, not here in the comfort of a courtroom, in the protection of a courtroom with deputies that are armed to give us that security. The law of self-defense requires each and every one of us to stand in the shoes of Curtis Reeves, a 71-year-old man at the time of this incident, a decorated law enforcement officer who had countless and countless hours of training in the use of force, in the assessment of danger, and the risks that take place when we are faced with a dangerous encounter. Curtis Reeves, at the time of this incident, had more knowledge, more experience, more study in that area than anyone in this courtroom, and certainly anyone that was responsible for investigating his fate. Perception. The prosecution came up here. I think I counted, we're probably at 28 to 30. It doesn't matter. This doesn't matter. This doesn't matter. This doesn't matter. This doesn't matter. And by the way, this doesn't matter either. And this doesn't matter. And by the way, this doesn't matter either. Ladies and gentlemen of the jury, everything matters. Do not discount anything. Do not discount anything that we do and we say and we present, and do not discount anything that the prosecution presents either. Because it matters. We live in the greatest country in the world that considers our system of justice the very best. And the very best because we have to consider the evidence. We have to analyze the evidence and judge that evidence. And this very court, the judge, is going to instruct you on a great deal of rules that you can apply in this case. I'm going to ask you to thoroughly review every one of them. We're about to start doing that ourselves. I'm going to take you first through those rules, and then I'm going to take you through every piece of evidence that came before you in this case. And it does matter. Matt, jury instruction number 1. Plea of not guilty. The court's going to instruct you on an instruction called plea of not guilty, reasonable doubt, and burden of proof. It is is the bedrock. It is the foundation of our system of justice. And one of the reasons that is one of the first ones is that that's where we start. This is where we start, all of us, in administering justice in this very courtroom. And what does it tell us? What does the wisdom of this law tell us? It tells us that Mr. Reeves has entered a plea of not guilty. And it tells us that this means that you must, not can, you must presume or believe that he is innocent. That's how we start this trial. There's a reason for that. There's a reason for that. Because it's not Mr. Reeves' obligation to prove his innocence. It's the prosecution's obligation to prove not only the crimes alleged, but is to prove beyond and to the exclusion of every reasonable doubt that the defense of self-defense is not present. That's his burden. So we start with that presumption. And where does that presumption go? That presumption stays with the defendant as to each material allegation. At each stage of the trial. Unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. Very powerful instructions for the protection of our liberties. Up a little bit, man. Let me take this off first. Okay. Reasonable doubt. That's a word that, again, you're going to be instructed by Your Honor, that you're going to be considering in this particular case. And so, wherever the words reasonable doubt are used, reasonable doubt is not a mere possible doubt, a speculative doubt, an imaginary doubt, or a forced doubt. Such doubt must not influence you. However, on the other hand, if after carefully considering, comparing, and weighing all of the evidence, all of it, ours and theirs, there is not an abiding conviction of guilt. An abiding conviction of guilt. Or, even if you have that conviction, but it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond and to the exclusion of every reasonable doubt. That's your guidance in this case. And one that, no, we cannot say that doesn't matter. That is not our system of justice in America. Where do we look? Where do we look for that reasonable doubt to determine guilt or innocence? Where? It is to the evidence introduced at this trial, and to it alone, that you are to look for that proof. And to it alone that you are to look for that proof. Where can that reasonable doubt arise? From the evidence, conflict in the evidence, or lack of evidence. Now, the prosecution says, look, we had horrible law enforcement officers. It doesn't matter. It doesn't matter. I about fell out of my chair. It always matters in our system of justice. It always matters. If you have a reasonable doubt, you shall, not can, not possible, you shall find the defendant not guilty. Because it's their obligation and it matters. I need to blow it up on that last part. Thank you. If you have no reasonable doubt, then you shall find the defendant guilty. It goes both ways. Next one, Matt. Justifiable use of deadly force. This is an instruction that the court is going to give you, and you are going to be able to work with this instruction for a very important function in your decision. Justifiable use of deadly force. Our Constitution, the laws in Florida, protect us as citizens to be able to defend ourselves in the face of danger. That's why these laws were enacted by the legislature, and that's why we have a Constitution not only of the United States of America, but also a Constitution of the state of Florida. And in looking at this instruction, the use of deadly force is justified if Curtis Reeves reasonably believed that the force was necessary. Remember what I told you from the very beginning? You don't judge a person until you have walked a mile in their shoes. That doesn't say you judge Mr. Reeves by what the prosecutor here has experienced in life. You only judge Mr. Reeves and you step in those shoes as a 71-year-old former decorated law enforcement officer that not once in his entire career fired his weapon in the line of duty, that was asked to start one of the most dangerous squads that you could have in a law enforcement department. An individual that traveled the entire country to learn those cues to prevent that danger from happening. In the law of self-defense, it doesn't tell you, get smacked first, Get punched first, and then you can see what you can do. Because as their witnesses themselves have told you, law enforcement, medical examiner, you name it, one punch can cause great bodily harm, and one punch can cause death. You've got to stand in the shoes before you judge someone. What else was in those shoes? What else were in those shoes? You were in a theater, in a darkened time of that theater. Previews were playing loud. The distance between Mr. Reeves and Mr. Olson was extremely short. You remember an opening statement, Mr. Lawswasser said, "Oh, he was in that row way over there." Did they even give you any measurements here? Not a single measurement was given to you by the prosecution. Because they want you to think that that particular distance was a row way over there where this was happening. But that doesn't work, because you've got to stand in the shoes of Mr. Reeves as he was seated there in that seat at very close range to Mr. Olson. When you're applying this very instruction, because Curtis Reeves reasonably believed that the force was necessary to prevent, let's circle it, prevent. You don't get a punch first and then you get the justifiable right to defend yourself. That's not how it works. To prevent imminent death or great bodily harm to himself while resisting an attempt to commit the felony offense. We're going to talk about this one. The felony offense of battery on a person 65 years of age or older. Now, the wisdom of the law. 65 years of age. If I go over to Miss Flores, and I go to Miss Flores and she doesn't want me to touch her, but I do this. It's called a misdemeanor battery. Miss Flores is, I won't tell you her age because she's young. But the law has recognized that the aged in our community are vulnerable. And they have sought that wisdom to say, if the aged are vulnerable, we've got to protect them. Because one battery, one misdemeanor punch could cost them their lives. That's not Rick Escobar saying that. And that's not this prosecutor saying that. That is our legislature that have, through countless studies, have determined that we've got to protect those that are most vulnerable. And so they've elevated, think about that, they elevated a misdemeanor crime to a crime of a felony that you can spend 5 years in the Florida State Prison.
Objection, improper argument.
It's a felony of the 3rd degree. That you can spend 5 years in prison if you batter the aged. Now, let's continue. A person is justified in the use of deadly force, again, if he or she reasonably believes that such force is necessary to prevent imminent, hasn't happened yet, imminent death or great bodily harm to himself or to another. Or to another. Who did we have in this theater seating in rows 9 and 8? Curtis Reeves, Vivian Reeves, both up way beyond 65 years of age. The imminent commission of an aggravated battery. That's another way. Not just someone 65, you can do it this way. Totally justified. There's another way. If in fact someone's their witnesses, not even mine. I brought officer after officer. Officer, tell me what can cause great bodily harm, which is an aggravated battery. Oh yeah, fist can, phone if it's being used as a weapon. Just about, I believe one officer said, just about anything can be used as a deadly weapon. Up a little now. So those two sections give you, this is what can justify the use of deadly force. But now, how are we going to make that determination? Because in deciding, that next paragraph is in deciding whether Curtis Reeves was justified. So, in deciding whether Curtis Reeves was justified in the use of deadly force, you must, not can, not maybe, you must judge him by the circumstances by which he was surrounded at the time the force was used. All of the circumstances, his knowledge, his close proximity to the individual, the low lighting conditions, the noise level, the problems that he was having physically. I think that when you all, and we're going to talk about Foley a bit later, not only did you hear from Dr. Foley, again, one of the preeminent radiologists in the country, not only did you hear from Dr. Foley, but he showed you on the x-rays and the MRIs some of the most trusted procedures that all of us in our lifetime at some point in time will have. And he showed you area by area by area of Curtis Reeves' problems. Disc herniations, impingements on the cord, his actual skeletal system from the very back. I'm not going to bring out the skeleton, but all the way down the back, he had black discs, all the way back, bone on bone in his hands, bone on bone in his back, bone on bone in his cervix. You've got to stand in those shoes because that's what the law requires. All of the circumstances, every single one of them. It's not what Rick Escobar would do. It's not what the prosecution would do. It's what someone in Mr. Reeves' shoes would reasonably do. That's the beauty of the law. It does not punish individuals that reasonably perceive that danger. That's the beauty of our Constitution. That's the beauty of the law of self-defense, that it does not punish the reasonable perception of an individual that is facing danger. And let's even talk about the danger because it goes one step further. It tells you the danger facing Curtis Reeves need not have been actual. Need not have been actual. That danger didn't have to be actual. But as long as he reasonably perceived that it was a dangerous situation, the law protects us. There may be other courts in the civil arena that someone can pursue, but in the criminal arena, the law does not punish those that reasonably perceive that they're in imminent danger of great bodily harm or death, even if that danger is not actual. The appearance of danger must have been, however, real, and that a reasonably cautious and prudent person under the same circumstances, again, would have felt that that danger was so real. It does matter. Everything matters. Based upon the appearances, Curtis Reeves must have actually believed that the danger was real. It's another very important paragraph right below it. And again, it's protected by the U.S. Constitution, the Florida Constitution, and our Florida laws. And as we walk in society, and as we interact with people in the great state of Florida, we're protected by these laws. And what does it say? That as long as Curtis Reeves is not engaged in unlawful activity, which there's no question he was not. He was at a movie theater, getting ready to watch Lone Survivor, watching the previews. So there's no question that there was no unlawful activity. And was attacked in any place where he had the right to be. Certainly he had the right to be at the Cobb Theater to watch The Lone Survivor. He had no duty to retreat and had the absolute right to stand his ground and meet force with force. Including deadly force. Those are the protections that all of us as citizens of this great state enjoy. It's a dangerous world we live in. Things happen in split seconds. It's very difficult to judge what comes next. It's very difficult to understand the makeup of that person that's about to attack you. But there are cues that officers, former officers, retired officers like Mr. Reeves have been taught that hopefully protects them and allows them to prevent that fatal blow to strike. Those cues. It wasn't only Dr. Bedard. Again, you know, they complained that our experts were expensive. Our system of justice wants that. They want to get it right. Our system of justice does not want to get this wrong. They complain that our experts charged an hourly fee to help in the investigation of this case. Roy Bedard, one of the nationally recognized experts in use of force. It wasn't my expert only, right? Remember what he told you on stand? Roy Bedard testified for this very prosecutor months before. This very prosecutor. He wasn't about to testify on this one for him.
Objection, improper argument.
Did they touch him with a 10-foot pole? Did they even come up and chat with him about his opinion? His opinion, which was the most important opinion, that Curtis Reeves did not fire that weapon in response to popcorn being thrown. His theme, his primary theme that he came up here, he said, ladies and gentlemen of the jury, this is about a man that shot another man over popcorn. Their expert witness, Roy Bedard, got up here and under oath said, absolutely not. 0.72 seconds between that period of those hands coming to grab that popcorn and the firing of the shot. Remember, Roy Bedard said there's an action and a reaction. The human body takes time to perceive what you're seeing, to decide what you're going to do from that act, and then to carry out the act. 0.72 seconds. Impossible. They didn't touch that with a 10-foot pole. They could have brought Roy Bedard for the government. Let's not even go to Roy Bedard. Let's go to Detective Aaron Smith. Remember all the questions I asked him about his training? Hey, we had training on use of force. Yeah, we have these training exercises, and we look at all these cues, and yeah, it's really scary, Rick, when we fail. Really scary, Rick, when we fail. Did you hear Aaron Smith get up here and say that the shooting of Mr. Reeves was about someone throwing popcorn on him? They had Mr. Smith right in their little palm right here to just ask him one, maybe two, maybe three questions on that issue. Not a peep. They stayed away from that 10-foot pole. I'm not going there. Again, it's constant. If he reasonably believed that it was necessary to do so to prevent death or great bodily harm. But here doesn't say that Mr. Reeves had to try to go and run out of the theater before he used deadly force. Perceives the danger, that danger is reasonable in his shoes. He can defend himself under the Constitution of the United States of America. He can defend himself under the Constitution of Florida, and he can defend himself under the laws of self-defense in the state of Florida. And if he doesn't, it could cost him his life. Another very interesting portion of the wisdom of the law. And our laws are very intelligent. Look what this section says here. In considering the issue of self-defense, the members of the jury, you may take into account the relative physical capabilities and capacities of Curtis Reeves and Chad Olson. Why does the law do that? Does the law do that because they recognize that a 40-plus-year-old man, 43, 40-year-old man, 6'4", 200-pound man, is much more dangerous when he is attacking a 71-year-old man with the physical problems that he had on January the 13th of 2014. Of course, that's what they're telling you. You've got an individual that has much more capabilities at 43 than an old man at 71, even if you don't consider his physical issues. You judge an individual after you've walked a mile in their shoes. It's a very wise old saying that has great practicality in the application of the law. If in your consideration there's an issue of self-defense and you have a reasonable doubt on the question of whether Curtis Reeves was justified, you shall. It would be a miscarriage of justice if we don't. You shall find Curtis Reeves not guilty. That's not me. The court is going to give you that instruction. The court is going to tell you the importance, ladies and gentlemen of the jury, of applying this law and applying these rules to the evidence that you've heard. There's absolutely no reason not to apply these laws. They're laws that we all follow as citizens, again, of this great country, to make sure that in each and every case, justice is carried out. A miscarriage of justice is the absolute worst thing that could ever happen in our system of justice. Matt, can we go to the next one? Transferred intent. I want to talk a little bit about transferred intent if we can, because it's a concept that sometimes you may need some explanation. But it's a short one, not a long one. And I think the prosecution gave you a little bit of insight that the intent transfers, the intent to do harm against one person, but you end up doing harm to another person, that intent transfers. But just as important is that if, in fact, if the death of Chad Olson resulted from the justifiable use of deadly force, if you find that the death of Chad Olson resulted from the justifiable use of deadly force, you must, not can, not maybe, you must find the aggravated battery or the felony battery or the battery of Nicole Olson was justified. Meaning the battery on her, the aggravated battery, the felony battery on her. You must find that it was justifiable. And why? Because the initial act by Curtis Reeves in defending himself against Chad Olson was reasonable in his shoes. For a second, we're not going to use the board. Want me to turn it off?
Yeah.
Ladies and gentlemen of the jury, who is Curtis Reeves? Who is Curtis Reeves? One of the most decorated, accomplished police officers in the history of the Tampa Police Department. You're going to have an opportunity to see, not all of them, because unfortunately back in those days, in the 60s. They didn't keep all of the training manuals and all the training documents. But you're going to see a stack of training that this individual attended and was certified all over the country. If you remember, he initially went into the Navy, and from the Navy he went to go work for GTE for a couple of years, and then he applied to become a police officer. An individual to serve our community. An individual that walked out of his home every day not knowing whether he would return. Not knowing whether he would return to his wife. Not knowing whether he would return to his children. And not knowing whether he would return to the occupation that he grew to love. Serving others. He had a mentor, a wonderful sergeant in the selective enforcement group. An individual that took Curtis under his wings and tried to teach him everything that could be taught to a 24-year-old rookie police officer. Those rookies face the dangers that veterans do. They're out there apprehending individuals that do awful things to others. Shootings, beatings, thefts, abuse, domestic violence, every single day. 8-hour shifts, 12-hour shifts, seeing the horror of our community day in and day out. It is no surprise that police officers that are out there on the streets must get the training that's necessary to avoid injury, to prevent injury, not to allow the injury to take place first, and then you get to do what you need to do. And Curtis, I think, told you, as he was testifying in this particular case, that he attributes his success within the department to that one sergeant that took him under his wings. And Curtis told you that his goal, when he was promoted, to do the same thing for others that sergeant had done for him. He was in patrol for a relatively short period of time. Curtis was a talented police officer. He rose through the ranks pretty quickly. Somehow, this prosecutor thinks that because you rise through the ranks of a law enforcement agency, that somehow you're just some mean individual that likes to go and just face danger and fight and do ugly things. I've been doing this for 37 years, 4 years as a prosecutor.
Objection, improper arguments.
That is not how law enforcement works in this country. As in every profession, you have good officers, you have bad officers. As in every profession, you've got good lawyers and bad lawyers. As in every profession, you have good doctors and bad doctors. But the title of law enforcement does not make you a bad person. Simple man, excelled at the academy, that was recognized from the very beginning, got the top award when he went to the police academy. I think even some of the officers that came here and testified told you how important it is that First Academy training is crucial. You're going out into the streets. And 99.9 of them are going out to the streets as patrolmen. And he went out as a 24-year-old, and within a year and a half, he was in that selective enforcement group. A dangerous position. Much more dangerous than even patrolmen. He's going and he's hunting these individuals that are committing robberies, that are committing shootings, that are abusing individuals, torturing individuals in our community. And he learned a great deal in selective enforcement because now the opportunities to go out and get training courses were much more available. He did so well in selective enforcement that he actually started some of the divisions that Tampa Police Department had never known. Tampa Police Department never even had a fugitive squad until Curtis and another officer formed that squad in order to go and arrest some of the most dangerous individuals in our community. It was clear in his career that the upper brass of the Tampa Police Department had the utmost confidence in his training and in his judgment to serve our community, to protect our community. And Curtis told you that as he was going up the ranks, he was actually even pulled into the detective ranks even before being assigned as a detective for 2 and 3 month intervals in order to help the detective division. And he learned a great deal from that division as well. That fugitive group exists today in 2022. How many years from its inception? Curtis obviously wanted to move up in the ranks, not because the ranks made him a control person, a bad person, but because with promotions comes income. He had a wife, 2 kids, going to school almost full time. Yes, the GI Bill was paying for his school. He's trying to make a living for himself and for his family. And he graduated from the University of Tampa, summa cum laude. Can't be any higher. For the Tampa Police Department to recognize his achievements, they recognize his dedication to our community. They recognize his intelligence in helping that department grow to be a much better department. Of course. And as he moved up the ranks, if you remember, one important part of his career is when he became a homicide detective for 5 years. What exposure did Curtis get when he went into the homicide ranks? One very important one, I will tell you, is that he had daily, weekly contact with the medical examiner's office. As a homicide detective, you go into that office and they're cutting on that body right there with you present. And as they're cutting on that body, they're dictating the reasons for these injuries, the causes of death, and it is an incredible educational process to the realities of how vulnerable we are, young and old, to violence. You're reminded that in a moment's notice, you can be alive, and in a moment's notice, you can be crippled or dead. It's an experience that most of us in this country, we don't get to know. We just don't get to know it. We're not exposed to it. We can't feel it, we can't touch it, we can't hear it. Curtis Reeves saw it every week. Those experiences don't leave you. They don't vanish. They stay with you forever. He was a wonderful homicide detective. A no stone unturned homicide detective. Because it does matter. It does matter. Don't let the prosecution tell you that it doesn't matter. Because it does. In his career, probably the most prestigious.
Objection, improper argument.
In his career, he was asked, along with one of the other sergeants, to form the tactical response team for the Tampa Police Department. Let's even think about that responsibility that was given to him and why. The tactical response team was called out for the most dangerous situations that the law enforcement community confronts day in and day out. It was not only a responsibility to actually formulate the blueprint of that team, but more importantly, it was the responsibility to make sure that the men and women that were going to be part of that team were going to have the tools necessary to come home to their husbands and wives and children.
Objection, improper argument.
That's the responsibility that was put on his shoulders. And in carrying out that responsibility, he had to go travel the country to make sure that he could find out as much as he could about the risks of danger and how to prevent his fellow officers and himself from getting hurt or getting killed. You know, back in that period of time, I'm sure that it wasn't as sophisticated as it's becoming even today. But those same cues are available. You certainly want to create distance from the person that's attacking you. Why? Because the shorter the distance, the greater the danger, the quicker that individual can strike, cause great bodily harm, or kill. Riding level puts you at a disadvantage. Even Detective Smith told you that. He also told you that noise puts you at a disadvantage in those situations. And why? We get our information from here and from here. And if you're in low lighting situations and noise is loud, you're putting that individual in the greatest of disadvantages. Relative physical capabilities. If you've got someone that is a big fella, young fella, and you're a 71-year-old individual with all kinds of medical issues, it puts you at a disadvantage, no matter how much training you've had. The training is to prevent. The training is to prevent. And so he formed this tactical unit that in 2022 is still in existence at the Tampa Department. 15 years. 15 years he commanded that unit. And not once in his entire 27 years of law enforcement, not once, did Curtis Reeves pull a gun and fire that gun at anyone.
Objection, improper argument.
It's in evidence. 27 years. He's not a trigger-happy, retired police officer. After 27 years, Curtis decides to retire. Old doors close, new doors open. His reputation at the Tampa Police Department was...
Objection, improper argument.
Why do we think that such a large corporation as Bush Entertainment would want to hire Curtis Reeves? 30,000 to 40,000 people visiting that amusement park on a daily basis. Why do we think that that responsibility was placed on his shoulders? That responsibility was placed on his shoulders because Curtis Reeves was going to do everything humanly possible to make sure that Bush Entertainment was safe. Curtis told you how he had to change from a law enforcement mind to a corporate mind, because what are corporations concerned with? They don't want anybody hurt at their amusement park. They don't want to get sued by anybody at the amusement park. And they want people to have a happy experience so that they can return. Profit and safety are at the forefront of those corporations. And so, what did Curtis tell you that he did? He just said, oh, well, I'm a police officer. You listen, Captain Curtis Reeves, I don't need to go to any of those courses of yours. I'm going to handle this my way. Is that what he told him? Just the opposite. He went to training after training after training after training in order to make sure that he could develop and know and understand the tools that he was going to need in order to be the best director of security that Busch Gardens had ever had. It was a great job. It's a great corporation. It's a big corporation. you're going to be able to see not only the training that he received in the Tampa Police Department, at least the majority of them, but you're also going to be able to see all of the certificates and all the training that he received from Bush Entertainment, because fortunately it's a corporation, so we're able to get more of those because they keep them. For 12 years, he served 12 additional years, 27 at TPD, and now 12 additional years as head of security for Bush Entertainment. We didn't hear anybody coming in here and say, you know, that Curtis, when he was a member of Bush Entertainment as head of security, he was a wreck. He was reckless. He was mean. He was out of control.
Objection, improper argument.
Didn't hear a peep. Because Curtis Reeves was an outstanding head of security for Bush Entertainment. It was a great job, he told me. But unfortunately, his health dictated otherwise. It's the realities of us getting old. We want to keep doing things that we did when we were 30, 40. But we realize when we get up every morning that there's reminders. Reminders of the aging process. Reminders that we want to forget. That we really don't want to confront. That we don't want other people to see. It's that fear if we stop walking and doing the things that we've always done, that we're going to end up in a wheelchair.
Objection, improper argument.
What did Dr. Cohen? Dr. Cohen was not, some expert that we, picked that was traveling around giving expert testimony. She was the professor right here in our community, at the University of South Florida, that developed the first aging studies here at USF. Incredible experience throughout the country as far as academic experience. What did she tell you about the aging process and what it does to everyone? We all get there. Some people a little sooner than others. Some people a little later. Some people a little different. But we all get there. And when we get there, it's a scary place. Because we know that it doesn't necessarily get better. We know that as our bodies deteriorate, as Dr. Foley told you, it doesn't happen overnight. It takes many years for that process to take place, and it gets worse. With every single year, it gets worse. And you go to bed at night, and you're reminded of that. You wake up in the morning, and you're reminded of that. And when you pick up your grandchild, you're reminded of that. And so Curtis Reeves being reminded of that day in and day out. Retired from a job that he likewise loved with entertainment. I think Jennifer told you at the time her dad was invincible. He could do everything. Physically fit, kept in tip-top shape, and loved the outdoors. I think she told you that Curtis didn't want to give that up. You may not be able to hunt like he used, but any glimmer of that hunt was worth whatever pain he was enduring.
Objection, Your Honor, this is improper argument.
It's not a proper argument, that's what she testified about.
All right, I'll overrule.
For those that are hunters, being 10 feet up on a tree may not be viewed by many as really hunting. We're normally 30 feet up in the air because you don't want that game to see you. He makes a big deal that this apparatus, which is so easy to get in and go in, is some testament to you all that Curtis Reeves is some robust hunter from the year of his 20s. As citizens growing old, as Dr. Cohen has told you, you want to avoid sitting down and withering away. And so he goes on his life now to retire and spend time with his wife, built a new home. These are precious years. They're your golden years. You build a home for retirement. You want to enjoy it with the most important person in your life. Someone that's been by you for 50 plus years. Who better knows Curtis Reeves than Vivian? All his pains, all his aches, all his inabilities. She's right there with him. Unfortunately, she's going through it herself. And so life with your long-lived life and partner, your wife.
Objection, improper sympathy arguments.
Sustained.
So life in your goal can be wonderful and likewise can be painful.
Improper sympathy arguments.
That's approach.
Matthew Reeves, likewise, talked to you about his experiences throughout the years of his father. In fact, he was the one that had gone to that hunting trip right before this incident occurred. It's important to listen to all the evidence because it matters. Curtis Reeves was an individual that was quickly deteriorating. Dr. Foley told you that. And on January the 13th of 2014, that is exactly the person that walked in to the Cobb Theater with his wife to watch Lone Survivor. It was a matinee on January the 13th of 2014. It was a time for Curtis and Vivian to enjoy what they did often. Go to a midday movie, see what the previews are showing for the future, so you can stay active and go to another movie. And both Vivian and Curtis told you that they were going to meet their son there. And even though Curtis had been on this hunting trip with Matt, it was important for Vivian to spend any time she could with her son Matt. Matt was running late. You remember in the video, we're going to show some videos a little bit later on. They were there in that lobby after they entered. They were in that lobby for some time, wanting to see, whether Matt was going to show up or not. And they knew he was going to show up, but what time was he going to show up? And they eventually went and bought one popcorn and one drink to share. You remember Vivian saying, "I brought my little baggie so that I could put popcorn in that baggie, and I could eat popcorn in my baggie, and Curtis could eat popcorn from the bag." Curtis, as being a retired law enforcement officer, and as he indicated on the stand, being encouraged by a federal statute that encourages retired police officers to carry their guns everywhere. Well, let's think about that. Talk about the wisdom of the law, remember? Why is it that we have a federal statute that encourages retired police officers to be armed at all times? Because those police officers are needed at times to protect our community. They're needed because we live in a violent society, unfortunately. They're needed because we don't know when that next violent episode is going to take place. Had a carry concealed firearms permit as well. And he had a little itty bitty gun. Not a big one. Not a Glock 44, strapped to the side of his pants to show how tough he was. It was a little gun and a little styrofoam poster that you put in your pocket, that you're encouraged by a federal statute to carry. Remember, this is the same gentleman who testified to this that he had never pulled his weapon in the 12 years that he
Objection,
served.
improper argument.
It's testimony. This is the same gentleman that did pull his firearm and shoot anyone in the 12 years that he served as head of security for Bush Entertainment. So they go into Theater 10. By the time they get there, Mr. and Mrs. Olson are already there. They sit behind Mr. and Mrs. Olson. Some point in time, commercials are on. Not previews, commercials. Mr. Olson's playing with his phone. No big deal. No big deal, because at that point in time, it was commercials. The announcement hadn't come on to turn off your phones. And then the announcements come on. And it wasn't just a little bitty announcement. You remember what Mr. Hamilton said, former deputy for Sumter County. Remember what he said? Man, they were playing that announcement to turn off your phone so much that I felt like pulling out my own phone. Because it was over and over and over again to make sure that the experience for everyone in that theater was a good experience. As people, as citizens of this community. Is that not what we all want for each other? The prosecutor calls it, with Mr. Reeves having that light shining on his face and leaning forward and saying, "Sir, could you please turn off your phone because the announcement went on." He calls that instigation. Again, I almost fell off my bicycle. Instigation. Is that an act of instigating anything? As people, can we not talk to each other and say, "Sir, can you turn off that phone, please"? Is that the prosecution's theory? That somehow that was instigation? Curtis told you, profanity. Fuck you, or fuck off, or fuck off. Fuck off. This 40-year-old man telling this 71-year-old, fuck off. Curtis leans back in his chair, waiting to see if maybe he was going to turn his phone off because he saw Nicole kind of maybe interceding to some extent. And when that wasn't happening, you see him again, "Sir, you leave me no choice, I'm going to have to tell management." Now, let's think about that process. Is that a familiar process that certainly he was accustomed to as head of security for Bush Entertainment? Remember, he told you part of the training that he had received at Bush Entertainment is that, hey, if someone's having a problem with a patron, don't deal with it yourself. You go and get a manager who has the authority to deal with that particular problem, and let the management take care of it. He thinks that's instigation. So I guess everyone at Busch Gardens are instigating because they go and tell management about an unruly individual at their amusement park. It's a darkened theater. Can I tell you how dark it was? Unfortunately, we can't. Whose fault is that? Whose fault is it that we can't tell how dark that theater was? You think Detective Proctor called Rick Escobar on his cell phone and said, "Hey, Rick, come on over, man. We got a shooting over here. I want you to try to preserve whatever you want to preserve." Now you can call Rick Escobar. Oh, Public Defender's Office. You know their number. Think that happened? In our criminal justice system, we rely on law enforcement to do things right. Because it matters. Because if they don't do things right, if they don't preserve evidence, the disadvantage that we face is insurmountable. I think Detective Smith told you, yeah, you're right, Rick, we preserve it not only for the prosecution, but we have to preserve it for the defense as well. And he's telling me over here it doesn't matter. Yeah, got a crappy investigative team out there, Rick. No problem. It doesn't matter. Just listen to me. Listen to him. That's what he's telling you. Just listen to me. Because all that doesn't matter. We'll get into Dr. Knox a little bit, but he was an expert in the field of crime scene reconstruction. That's what he teaches. Not only in Jacksonville, but throughout the country. Law enforcement officers from all over. He told you the dangers of not getting it right. He told you the dangers of missing those pieces of evidence that can shout out the truth in a criminal investigation. It doesn't matter to the prosecution because they're not being accused. That's why it doesn't matter. But for anyone that's accused, oh, ladies and gentlemen of the jury, it matters. And so Curtis leaves that darkened room, whatever darkened it was, and goes down the road and goes to the manager. And you're going to a little bit see that again. You'll have it in your deliberation room. You'll have a computer, a defense computer and a prosecution computer. You'll be able to look at all the videos and analyze all of that, and I encourage you to please do that. Because it matters. And so you'll see when he was talking to the manager, he was calm, he was polite, he was resting there on the counter. Remember Michelle Simpson was there? And what did Michelle tell you? Yeah, if they were there, there was no signs of any aggravation or hatred or being mad. Because Curtis Reeves has dealt with these situations countless times before. What did he tell you? He's a mouthy guy. And his perception at that point in time is that's what it was. He was a mouthy guy to get the manager take care of things, and everybody can enjoy the experience again. There's one very important, critical piece of evidence that you've seen in the videos. And that is he leaves the counter, tells the manager exactly where he's at when he's pointing, I'm up at the very top middle. And he comes back And the first thing that Curtis does when he comes back is what? He grabs the bag of popcorn from video. It's in the video. That's the first thing he does. Do we think, does the evidence show that when he comes back he wants to have any problems with anybody? He wouldn't be grabbing a bag of popcorn, I can tell you that. Because in his training, as he's told me, if he's about to get into something with someone, he better have both of his hands available. That slaps you right in the face. He grabs the popcorn from his wife and he sits down. It is at this time that there's that conversation by Mr. Olson where he is irate over the fact that Curtis has turned him in. And you got that from Mr. Cummings. You got that from Jane Roy. You got that from Curtis Reeves. This guy is upset that Curtis had gone and told on him with vengeance. And so the only thing that Curtis does is say, look, I see you turn your phone around. We've never gone to tell management. Had I seen that you were going to put your phone on? That he calls instigating. As human beings in this community, we can't have that kind of conversation. If we can't, God help us all. And so at that moment, he jumps up, that being Mr. Olson, and turns around, and the profanities and the attack occur. One thing I can tell you is, thank God for that video. I have no idea why he thinks the video is good for him, but thank God that we have that video. As bad as it is, as limited as it is, because it only records on row A, you'll be able to see that and analyze it and do everything that you need to do. It's supposed to be recording the scene of bistro. Thank God we got at least a glimmer of a section in that camera that captured row A. I wish it would have captured row B. Had it captured row B, we wouldn't be here. And what do we see? Somehow, the prosecution tells you that the first attack is a fabrication. We're going to see the videos in just a few seconds. That first attack, Mr. Olson, is clearly, half his body is in row A. And coincidentally, while his body is in row A, we see this either reflective or illuminating light. You recall what Mr. Koenig said. It was 6 pixels. Rectangle. Madam Clerk, can I see the cell phone? Please. Rectangle. Not square, not round. Rectangle. 6 pixels. Now, could we prove to you all that the illuminating or the reflective light that we're able to see as you see that body coming over onto row A, can we tell you for certain that this is what it is and that it is not Curtis's shoes? We tried. We spent a lot of money, experts flying from all over to get to that cop theater to try to prove with a cell phone in our hands and the actual shoe to try to determine what was that light source. And through no fault of the defense, and through all the fault of the state of Florida, we couldn't do it. Because the cop theater was pretty savvy. They had come in, taken all the hard drives in the middle of the night, on the night of the incident, from the cop theater with a patrolman, and I don't know what he was, with a patrolman there, cordon off Mr. Sillis. My name is Mr. Sillis. I'm here to come get some evidence. Sure, come on in. Go upstairs, take all the evidence. Cop theater flying someone down from Alabama. Here, sir, take it back to Alabama. And within 60 days, not only had they taken the hard drive, remember Mr. Peck, what he said, they had dismantled and taken the entire surveillance system. So when we arrived at the cop theater in the middle of the night, 2 or 3 o'clock in the morning, as Mr. Koenig told you, we couldn't do anything. It was a total waste of time. Because the responsibility of preserving that evidence was there the evening of January 13, 2014. I will tell you that they had, and you heard the testimony, they had Detective Busson, they had Detective Papinella, they had Detective Lindsay that had just gone briefly to the hospital. The 3 guys that had started the most respected unit in the Pasco County Sheriff's Office, the cyber crime unit, right there to do everything that we were prevented to do in that theater. They could have done it right there. And for one reason and one reason only, it didn't happen. Because Detective Smith now was assigned as a lead crime scene detective, prestigious position, and he decided that no, nobody was going to do anything. He was going to do it all. Remember, it was the second time ever handling a crime scene investigation on a homicide case. Detective Smith had not even taken the mandatory homicide course. He told you himself. No, hadn't taken that yet. And who was his shadow partner? Detective Proctor was the person that was supposed to teach Detective Smith. Now, if that's not the blind leading the blind, I don't know what is. Detective Proctor was cross-examined by me. And he had to admit from this very stand, he didn't want to. How long did it take him to admit? It was radio silence. Detective Proctor, you were not equipped with the knowledge. Detective Proctor, you were not equipped with the knowledge to handle a self-defense case. Because you, Detective Proctor, had only handled one before. And then there was that radio silence. And he finally had to admit, yes, Mr. Escobar, I didn't have to. I didn't have the experience. It took Detective Proctor 8 years to admit that he was not equipped to handle this case. Let's think of, it doesn't matter. It doesn't matter. Detective Proctor had told Sergeant Sessa, "Hey, Sarge, I know I wasn't supposed to be assigned to this in the very beginning. Detective Soto was. But I don't have the knowledge." He waits 8 years to get before the ladies and gentlemen of the jury. The first degree.
Objection, improper argument.
Suspend.
It matters. We're going to go through the next very important part, because the first attack is as vivid as it can be in that video. Now you remember, you heard testimony that both sides had the FBI. I don't know where their FBI guy is, but my former
Objection,
FBI.
improper argument.
You heard from my FBI guy. They complained about him as well, that he was costing money. We brought you one of the leading experts in the country in video surveillance, analysis, and enhancement. Mr. Koenig has worked on the most important cases ever in this country. Fortunately, he lives right over here in Pinellas Park now. And what did Mr. Koenig do for us in those videos? He told you about a concept that is very, very important. It's called interpolation, you remember. And then when you're doing forensics, you've got to make sure that if you're going to enlarge or enhance that video in any way, it's got to be done a certain way. And that's called the pixelation of nearest neighbor. Because if you don't do it that way, there'll be problems. It's not forensically correct. And he told you what happens to big screens when we put things on. And that particular film and video have not been processed correctly with nearest neighbor. Because we don't know what's in the brains of this thing, he told you. We don't know what the algorithms are to make something that's being presented on this screen bigger. Remember we talked about the number of pixels, and through interpolation you could have 76,000 pixels, but if it's improperly interpolated, you can have 6 million, 12 million pixels that were never in that particular film and video to begin with. And guess what? You don't know what they're doing with it because it's proprietary. They don't want to release the secret so that a forensic expert can analyze it and make sure that what you're getting is truly forensically correct.
Objection, improper characterization of the testimony.
Suspend.
And so, what happens? First attack takes place. We brought you that video. We're going to see it in a few minutes. We actually put circles around the two particular areas of focus. The reason that Mr. Koenig did that, because he wants our eyes to be focused on that. We did it both ways. We did it without the circles. We did it with the circles. We did it at 200% magnification. We did it at 400% magnification. But he told you one thing that was important. Forensically, this was accurate. We're not putting any pixels that weren't there to begin with. And so you're able to see at 25% playback, 50% playback, 200% magnification, 400% magnification. That was a monumental task. So that you would see the truth. Because when you see that archaic video, remember he told you, was worse than the quality of the first TVs that came out in America. When you see that video in a raw form, that first attack happens so quickly that you're not able to focus on it. Obviously, when we're in a court of law, we want you to focus on everything because it matters. Because it matters. Curtis Reeves, with years of his experience, was being attacked. You know, the prosecution came up here and said, if the phone was thrown, remember the left hand? You see how I just picked up this phone, right? The left hand. What hand was Mr. Olson holding the phone in as he was scrolling? It wasn't my witness. It was his wife, who said Chad had his phone in his left hand, and he was scrolling. He was scrolling. So phone in the left hand. You see that first attack? That's exactly what happens. What does Miss Turner tell you? Does Miss Turner tell you that the phone's in the right hand? Or does Miss Turner tell you that whatever object she saw, whether it was a thermos or a mug in a darkened theater, was being flipped or thrown with which hand? The hand that Chad Olson carried his phone. Now somehow, the prosecution wants you to think that somehow it magically got from Mr. Olson's hand, left hand, and somehow it got in between Curtis Reeves' legs by pure magic. Did they have anybody, forensically or otherwise, come here and tell you that it just floated in the air just out of mystery and it landed in between Mr. Reeves' legs? Take a look at a very important aspect of this video, that first attack. You'll see the body going over, and you'll see a light. At that same time, you see a light. Now, let's talk about that. Remember, we wanted to tell you here today whether it was the phone or the shoe. We were not allowed to do that through their own fault, not ours. Could it have been the phone, that light that you saw? It could be. Could it be the reflection of his shoes? Of course. Unfortunately, in this case, to make matters worse, because they didn't preserve things as they should have, we've got a shoe that reflects as well. I would have loved Curtis to have sandals that were not reflective. Trust me. But now we've got this particular issue. It doesn't matter whether it was the phone or the shoes. This is the only thing that it doesn't matter, because it's clear that that phone was in between Mr. Reeves' legs. Immediately was seen by Mr. Hamilton after the shot was fired. Immediately. Now let me point out something else. If you say, okay, it's not the phone, and if you say that it's Curtis crossing his legs, it could very well be. Why was that crossed leg at that very moment moving in order to show the reflective characters of that shoe? Why? Why? Because Mr. Olson, you can see, is coming over the back of his seat towards Curtis. You know, the real problem with the phone issue, the reason that we went there at 2 o'clock in the morning, is that you have camera 11 and camera 12, right? There's the screen of the theater, camera 11, camera 12. These cameras One camera is recording, the other camera is not recording. There's no rhyme and reason. It is the dinosaur of dinosaurs as far as surveillance system is concerned. You think to yourself, complicated? Are you kidding me? But this is the problem. If the phone is not illuminated at that time, for whatever reason, it's a darkened theater. Are you going to get a light? Are you going to capture that illumination if it's not? This is black. Same thing here. If the phone is being thrown, depending upon all the positions that a phone can be thrown, and that light is not on, are you going to capture the illumination? Six pixels was of interest to us. 6 pixels. We could do what Mr. Knox and Mr. Koenig wanted to do, is to bring that evidence to you for one reason and only one reason. Law enforcement failed to do their job. And so you'll see that there's about 8 seconds between the first attack and what I call the second attack, the popcorn incident. And remember, we had Mr. Knox, we had quite a few witnesses, Mr. Koenig, tell you that what someone is experiencing in that particular chair cannot be captured, that perception cannot be captured exactly from a camera that's 35 feet up in the air. Now, if the camera was right there, see what you were seeing, to witness what you were seeing, that would be wonderful. We don't have that. And remember, whose perception is it? In whose shoes do we need to step in? The shoes of Curtis Reeves. It was he that was experiencing the attack. It was he that was feeling that particular item hit him on the head. Mr. Reeves, can I have your glasses? Let's hope that I do as well as I did before. It's old man glasses. They move everywhere. I'm not, the arms, the center, you name it. Everywhere. You think that they even looked at this forensically? You think they even used it in their attempted recreation? No, because they didn't have a recreation. We don't even have measurements from them. And does that particular area, something hits that particular area of the glasses, will it hit your eyelid? Something hits that area with some force. Will it cause some injuries to your eyelid? And the prosecutors picked this up. You don't want to touch it too much. I'm touching it. I want you to know the flexibility. You all grabbed it and did everything. Legs, arms, whatever you want to do with it. Curtis Reeves was hit with a phone. That's without doubt. His own medical expert, his own medical examiner, sat there and said, you can throw a phone at somebody and not have any evidence that it was thrown and hit the face. He said that right up there.
Improper characterization of the evidence.
There's so many variables. There's so many variables. Just because you throw a phone at somebody and it hits them in the head doesn't mean that it's going to split their head open, because we don't know what the force is. We don't know if it hit something before it hit the head. There's a gazillion variables that you have to consider. But we know this. They didn't even think of this. And remember, Detective Koenig, telling you that he told the tech, forget her name because she didn't have a major part, but let me see if I can quickly find it. Susan Miller. Remember Susan Miller? Koenig tells you, I told Miss Miller that she needed to take a picture of Curtis Reeves' injury to the left side of his face. Susan Miller told you, oh, absolutely not. That was an injury that I saw. Nobody told me that. And I documented it because that's my job as a forensic investigator to do that. And you've got the picture. It's their picture. And you will see that Curtis does have a red mark. Of course, now they had to figure out, oh, well, you know, he rubbed that area, and so now he's fabricating that he was hit with a phone, even though the phone is in between his legs. Sorry, Curtis. That second attack, what are we seeing from seat 9A? If we were in seat 9A, what would we be seeing? We'd be seeing those hands coming at you. That's what we would be seeing if we were in seat 9A. That is what Curtis Reeves would be seeing. Curtis told you that after that first attack, his glasses were a bit askew. Now, you've seen those glasses. Now, if it was my glasses, it'd probably be, you know, because they're so
Objection,
stiff.
improper argument.
My glasses would be stiff.
Objection, still the same argument. Doesn't matter what Mr. Escobar's glasses can do.
Mr. Reeves' glasses are flexible. And so he's seeing those arms coming at him. He told you before that situation, I knew that I had to retrieve my firearm because this guy was coming at him. And his, Mr. Olson's very wife was trying to hold him back and couldn't. I want you to think about that. Here's Mrs. Olson. Her husband has got to be somewhere either directly in front of her, whether she's seated halfway or totally up, or to the right of her. She's using her left arm to hold him back. Now, that's pretty awkward if he was here, but not so awkward if he was right in front. Why would Mrs. Olson have to hold her own husband back? Because she knows his violent tendencies?
Your Honor, that is
That's
completely
that's
improper and evidence that is not before this court.
here, because the screen is in my way, that's where I'm sitting by the jury, so I can see the jury. Ladies and gentlemen of the jury, you'll disregard the last statements made by counsel.
So tell me, what does the evidence show as to why Mrs. Olson had to place her hand at or around Mr. Olson's chest? What was she trying to prevent? On his chest. Not, hey dear, calm down. Not, hey dear, calm down. Forensically, Mr. Olson's hand is in front of his thorax during bloodshed. Miss Olson's hand is between Mr. Olson's hand and the chest. What was she trying to prevent? We know that Mr. Olson wasn't doing this at the time of bloodshed. We know Mr. Olson wasn't doing this at the time of bloodshed. But a fist is consistent with the evidence. And we're going to look at that photo in just a bit. Curtis knew that he was under...
Object to him using the first name of the defendant.
Surnames, please.
Mr. Reeves was well aware, based upon his training and experience, that he was in a very dangerous situation and that he had to act quickly because the distances between Mr. Olson and himself were minimal. And that awful things happen in fractions of a second. Fractions of a second. A tragedy took place that day. Two tragedies. Mr. Olson died. A family lost a husband. A child lost a father. And Mr. Reeves.
Objection, Your Honor. This is inappropriate whether it's on the state's behalf or on the defendant's behalf.
It was a tragedy. And so what happens thereafter was also a tragedy of insurmountable magnitude. The investigation. We're going to go through every part of that investigation and analyze exactly what evidence you heard and what evidence you didn't hear. Alan Proctor mentor of Darren Smith, was not supposed to be assigned the lead detective role that day, if you recall. He said Detective Soto was supposed to be assigned, but he was on the other end of the county. And so I guess one of the supervisors said, okay, well, Proctor, you're on. He never even goes into the crime scene before he starts interviewing the first person. He never goes into that scene. He's the lead detective in this case. What do we think about that? And he ends up initially interviewing Corporal Hamilton and his wife. And so if you believe Corporal Hamilton, he will tell you two very important things. Corporal Hamilton will tell you that, number one, he and his wife were interviewed together. Both of them. In other words, in his interview, his wife was there, and in her interview, he was there. And that somehow they had some special procedure going on, Detective Proctor, that before he turned on the recorder, he wanted to determine whether a corporal from the Sumter County Sheriff's Office, what he was going to say. Whether he was of the right mind, I guess. And even Corporal Hamilton told him, you're not supposed to do that. You're going to record an interview, record it from the very beginning, and preserve the evidence. Because remember, we're preserving the evidence not just for the prosecution. We're preserving the evidence for everybody. Prosecution, the defense, and most importantly, the community in our system of justice. And Corporal Hamilton, finally on cross-examination, says, yeah, Rick, you're right. Really, what I saw was a silhouette. Well, wait a minute. If all you saw was a silhouette, then what's this bit about, man, you can see 10 seats down, you can see 20 seats down. It's as clear as day during those previews. Why? Why can Corporal Hamilton only see a silhouette? Never see Mr. Reeves. Never see a gun. Because the reality is that it was dark. And why can't I provide you that evidence? Through no fault of our own. It was never preserved. Remember, Mr. Knox told you, light meter, noise meter, it's a no-brainer. Things have been used in investigations forever. But what was told to you here in this particular courtroom that's even more powerful? You remember, I believe it was Amy Parrish, if I'm not mistaken, it was the forensic tech that Mr. Michaels was interviewing. And she says, I've got a specialty. My specialty is be able to actually photograph accurately in dark areas. Now that's like the no-brainer, right? You got your forensic investigator right there. You got Detective Aaron Smith right there. You certainly want to, as all the experts have told you, you want to be able to stand in the shoes of Mr. Reeves and capture everything that he was seeing, everything that he was experiencing, and you don't do it. You remember their photography was such a disaster that they had to come back 2 weeks later, even under Aaron Smith's, remember he told you, my main focus there at the crime scene was I wanted to make sure that they had good photography. Of course, the spotlights that they needed were right outside in the parking lot of the forensic lab truck that they never used. Instead, they brought flashlights. So they bring flashlights, they don't use the equipment that's in the truck, and by all means, let's not use your expert that can actually photograph in the dark and replicate that lighting. So what do we do now in our criminal justice system when that has disappeared through no fault of the defense? but all fault of the government. He says it doesn't matter. You judge for yourself. So Mr. Proctor, Detective Proctor, now Mr. Proctor, he interviews both of those individuals, and clearly, from both of them, they tell him, hey, there's some profanity coming from that silhouette. It's coming back towards Mr. Reeves, and we don't hear a peep from Mr. Reeves. Unrefuted, clearly, profanity. The word, pardon, fuck, used in whatever way at that moment Mr. Olson was using it towards Mr. Reeves. Fuck! Does that indicate someone is mad? Fuck in a theater! Is that behavior that indicates that someone who's uttering those words has to be totally out of control? Who does that? Remember the environment. What's your environment? We're in a theater. You're supposed to sit down. Enjoy the experience. Watch the preview. Watch the movie. Quiet. It's peaceful. It's relaxing. And someone is standing up in a fit of rage, acting like, I would bet, nobody in this entire room has ever heard before. In a theater. Is that a cue? Is that a good cue to understand that the gentleman, if you want to call him that had already attacked you once, is about to attack you again, was out of control? But that's not important to Detective Proctor. Because remember, he doesn't know what a structured interview is. He doesn't know what a structured interview is for a self-defense case. He didn't even want to know what Curtis's experience was in being able to recognize danger, assess that risk, and act accordingly. Please, ladies and gentlemen of the jury, please listen to that interview of Detective Proctor to Curtis Reeves. The proper questioning, according to the experts, would have been, no, you've got to know details. Tell us what courses you've taken. Tell us how long you've been tactical. Tell us the experiences that you've had in the past, because why? Remember the law that we read here? The law tells us that's what we must do. Police officer, jury alike. We must stand in the shoes of the individual that was facing that danger in order to accurately understand their reasonableness. Doctor didn't ask any questions concerning lighting, noise. In fact, he didn't even know exactly where Mr. Reeves was seated. You think he said, hey, Curtis, come, we know you're not a danger because we just put you in the front seat of the patrol car. Come on with us. Let's, sit down here. Let's get the movie theater to put the movie theater at mid-level 1. Do we think, does anybody think that Curtis Reeves would have been a danger under those circumstances? Come on, Curtis, sit over here. Okay, let's put it at mid-level 1. Let's get those previews that were playing before. Let's get them going. Let's talk about it. So that not only Mr. Reeves could have explained the circumstances to Mr. Proctor, but even more important, so that Proctor himself could understand that experience. Because if you're not sitting in the shoes of Mr. Reeves, you're not following the law. That's what the law requires. That's what the law demands. And that is the foundation of our Constitution, nationally and in the state of Florida. And so you have a 30-minute conversation before he decides to charge my client. 30-minute conversation where none of the structured interview, as the guard and even their own officers have told you, none of those questions were asked. And you know what was the bomb of the investigation? You know what it was? The bomb of the investigation was that Detective Proctor said, you know, I interviewed Curtis, then I went back and I interviewed Mrs. Reeves, and then I went to the command group, my brass. And I had a discussion with them. And then I went back to Curtis. So thank God for recorders. They're a thing of beauty. Because we had timestamps on it. He didn't realize that. When you record something, you got a timestamp because they put it on the report. This recording ended at such and such time. This recording started at such and such. That's how you do it. So now we had timestamps. There were 5 minutes. Remember, we did the timeline. I kept writing so that the members of the jury could also follow along with that timestamp. 5 minutes between Curtis's last interview, where he had already told Curtis, hey, by the way, Curtis, I'm going to charge you, with second-degree murder. That was that was after the command center. And so I said, hey, here's the time stamp. And he was there with his pen, Mr. Proctor. Okay, I'm writing it down, Rick. Yep, I'm writing it down. And we came out with that 5-minute period. I said, uh-oh. That's a problem, Proctor. Did you notice his eyes, his facial expression when it was 5 minutes? I said, now let me tell you this. From Vivian Reeves' interview, you had to go to the command post. Yeah, that was right outside the theater. Okay, so how long did that take you? A minute? Okay, so now we're down to 4 minutes, right? And in order to get from the command post all the way to the back of the theater, where Mr. Reeves was, that about 3 minutes. You had a 1-minute conversation with your command post as to what you were going to do in the charging of Mr. Reeves. Is that the thoroughness that we expect in our criminal justice system? Is that the thoroughness that our system of justice demands? It doesn't matter. It doesn't matter. Detective Proctor. He admits it was a brief interview with Mr. Reeves. He admits he had absolutely no experience in dealing with self-defense cases. But he makes a decision within a minute with brass. Did he really go to brass? Did he make his decision? Is this a case that he really didn't want to investigate because it wasn't supposed to be assigned to him? Was it just dumped on him? His partner was supposed to be Aaron Smith, crime scene detective, right? He had just gone into the homicide unit in December of 2013. Why are we putting Aaron Smith as a lead crime scene detective when he just joined the homicide side of major crimes in December of 2013? Do we remember the number of police officers that were read out loud before jury selection? Monumental. 130 some witnesses. They had the entire battalion of the Pasco County Sheriff's Office there at the theater. Aaron Smith. That's the guy they choose. If you remember, he started doing interviews first, right? Because he wasn't supposed to be that either. When he first got there, it assigned him to do interviews. Now, did he become crime scene detective because Proctor, the mentor, suggested that's the position that he should have? Only doing one crime scene investigation before. As a crime scene detective, back as early as the academy, as the lead detective in the case, both of them, back as early as the academy, every single police officer that came before you, I asked that question. Tell me what was told to you as early as the academy. Rick, what was told to me is that I had to be very careful with the issue of contamination, witness contamination. Well, why did they want you to be so careful with that? They wanted me to be so careful with that because it is a big, big problem in that individuals that talk to each other, whether that information is right or wrong, they adopt that information as their own and start believing it as their own. And you can't, they testify, you can't undo it. Because you don't know reality from falsity. And how did we experience that here in this very courtroom? How do we know that happens beyond every expert telling you that came up here, every police officer? How do we know that? Let's talk about an interesting fellow by the name of Mark Turner. Mark Turner was married to Mrs. Turner, right? Joanna. And Mark Turner was called by the prosecution. Now they're saying, again, it's not important contamination. You experienced it here. What did Mark Turner tell you? He said, I came into the theater during the middle of the previews. And when I sat down, Mr. Olson was standing up. And he was facing Mark Turner. And he was standing up in front of what would have been Vivian Reeves. And he was just standing there. He was playing with his phone, looking at me. And when Mr. Reeves came up, because remember, Mr. Reeves wasn't even there. Mr. Reeves came up the stairs because he had been at the manager's desk. Now let's think about that. This witness that truly believes that Mr. Olson was standing up, playing with his phone during the entire time that Mr. Reeves was gone. Did you hear that from anybody else? How can a witness believe that? It's worse. And clerk, may I have the pictures of Mr. Reeves? So what he's just using a few minutes. Yeah. Mr. Turner tells you he sees Mr. Reeves coming up the stairs. And he's wearing a tan London fall jacket. Does that look like a tan London fog jacket to you? Does that look like a tan London fog jacket to you? How can Mark Turner believe in his own mind when he was this close to Mr. Reeves as Mr. Reeves passed by? And remember what he says about Mr. Reeves. Mr. Reeves said, "Excuse me." Probably the only thing he got right that day. How can Mr. Turner be so out of space, in orbit with this testimony? That's what happens. That's what the experts have told you happens. When you have a theater full of people that are in an emotional state, and as you're sitting there, you're hearing bits and pieces from every Tom, Dick, and Harry that is frantic about what just took place. And you're not having a single officer from the battalion that arrived immediately separating people, immediately interviewing people away from each other, and most importantly, also asking them at that very moment, tell me what you have done, who you have talked to, where you have been. And guess what? One more thing that would be really good. Let's get that surveillance camera to see where they
Your Honor, I asked the counsel to make the argument from the podium, it's not up at the jury bench,
Let's.
or at least walk around.
My apologies. I will back up a little bit. Let's get that video still rolling. Let's see where these witnesses were. Let's see who they talked to. Let's get that video from the concession area. Let's get that video from Theater 11. As the experts told you, contamination is one of the worst things that could ever happen at a crime scene, and you cannot rely on those people that have been exposed, and especially in a highly emotional scene like this one. Mark Turner. The prosecutor will tell you it doesn't matter if he was wearing a blue shirt or a London fog. Prosecutor will tell you it doesn't matter if Mr. Olson was standing the entire time or just a short time. It matters. All of it matters. Notes of conversations were destroyed by Proctor. Remember that 5 minute off, 5 minute on interviews? Oh yeah, I took notes. Where are they? Destroyed. It took Detective Proctor almost 4 hours to finally go into the crime scene. After he had made his decision to arrest Mr. Reeves, Detective Proctor finally goes into the crime scene. Why go then? You made your decision. Why go then? He said, I've got such faith in Aaron Smith. I've got such faith in Aaron Smith concerning his competency. Did he communicate to Aaron Smith that Mr. Reeves had indicated that, hey, I had seen a blur, I think I may have been hit with a phone? Aaron Smith told you, I certainly didn't know about that while I was inside the crime scene, and frankly, I can't even tell you when I learned that allegation. How can the crime scene detective not know that? They're supposed to be partners, working together. You know, I believe that had...
Objection, improper comment as to what the attorney believes.
I will rephrase it. Would Aaron Smith have allowed the tech investigators to pick up this phone had he known that there was an allegation by Mr. Reeves that this phone had been thrown and had hit him in the head? I would hope not. But the phone was picked up. It was turned off, which is forensically incorrect, as the expert told you that works for them. Who's someone? Not supposed to turn it on. It's turned it off. You're supposed to keep it on, put it on airplane mode. But if you need to get forensic evidence, I'm there, and we can get some things done so that we can extract the DNA. How critical is that to the truth? An allegation that a phone was thrown, someone got hit in the head. How critical is this? What's on this phone? 3 individuals' DNA are on the black case of this phone. But there's such a mixture of it that you can't tell whose it is. But the important part is that Curtis Reeves is not excluded. How important was this phone on January the 13th of 2014? Does it not matter? And so, Detective Smith is there in that crime scene, and really, what is he doing? What was he doing there for 3 hours? Did he get up there and tell you, hey, this is what I'm doing for 3 hours? The only thing he told you was that, hey, I was interested in getting good pictures, and he screwed that up. Because he had to go 2 weeks later to get more pictures because, the lighting wasn't too good because we had flashlights instead of the spotlights that were in the trunk. What else did Detective Smith do in this case? I can tell you. Right from under his nose, video evidence in this case was seized by a private entity and flown to Alabama. Do you think that when Detective Proctor went into that theater and he looked up and he said, ooh, got some cameras there, that could be wide angle cameras, hey, listen, I want to go see that immediately, certainly before I charge Mr. Reeves. He couldn't do that because he charged Mr. Reeves before he went into the theater. But could he do it after and say, well, listen, I've already charged him, but let me take a look at that video and let me see what it has, so that if it has something that corroborates Mr. Reeves's testimony, I can maybe uncuff him and say, hey, we're going to take this slow and we're going to really do our job here the way that we're supposed to do it so that innocent people aren't convicted. DNA and video. How many times in America do we see individuals that spend...
Objection, improper argument.
DNA. Can use it today. Can use it 20 years from now. 30 years from now, to find out the truth, with one exception. When you grab a phone and you mess with a phone and you destroy the ability to get DNA in its original form, in its virgin form. What did Detective Smith do to compound the problem? 2 weeks later, still had not been processed for DNA. Detective Proctor tells him, "Hey, Smith, I need to find out whose phone that is. Can you go into evidence and let's open up those packages and let's turn on that phone and see whose phone it was," despite the fact that they already had information from Mrs. Olson that this was her husband's phone. Who else's phone could it be? Well, wait a minute. Okay, you really need to find out. I get it, detective. Before we open the package, forensic investigators, come here. Let's swab the phone, preserve DNA, then you can do whatever you want with it. Nope. Let's get another glove. Let's grab the phone. Let's turn it on and continue to destroy evidence that was so crucial in this case. Was it total ignorance? Was it? It doesn't matter. These two detectives were a train wreck. And so they have to go to Alabama. Despite the fact that Busson, this was one of the greatest moments, I think, of this trial for Aaron Smith, because he got up here and he says, "Detective Busson is my friend. He's a good friend of mine. Detective Busson is." Like if somehow Detective Busson was going to protect him. And Detective Busson, because remember, Mr. Smith had said, "Oh no, it wasn't me. It was Detective Busson that had to go do something else, and that's why I took over the video process of this case." Detective Busson came in here under oath, despite the fact that he may be friends with Mr. Smith, and said, "Oh no, didn't happen that way. He was the one that told me, get out of here, I'm handling this." So what do we think about that? Can we have confidence? Can we have confidence in the investigation? Do we need that confidence? Or do we just say, it doesn't matter? Detective Busson, God bless him. What's ironic about Detective Busson is that who imaged the hard drives when they finally got their hands on them? Detective Busson. He told you what he would have done, certainly not giving the cop theater any authority to do anything with that. If he needed search warrants, whatever was needed, he was going to do it, he was going to image it, he was going to preserve it. Now somehow, 15 hard drives, 10 hard drives, impossible to decipher at this point. Because guess what? When they went to Alabama, they never opened the case. They never opened the case. Peck gets sued. They never opened the case. Some lawyer, not all lawyers, are trustworthy. Not all doctors are trustworthy. Not all architects are trustworthy. And yet some lawyer that's representing Cobb Theater, and they say, oh, thank you very much. You've given me this case. Oh, you've given me this list. Is that what's in there? Yes, that's what's in there. Okay, well, we're not going to open it. We're just going to take it over to evidence, and we're going to put it in evidence. There could have been 3 kilos of cocaine, and nobody would know until they opened it. Is that the kind of investigation that we demand in our criminal justice system, to have the confidence to make decisions? Or is that the kind of evidence that the law and the rules and the jury instructions tell us absolutely not? You've got a burden, and you better meet it with evidence that we can feel comfortable and reliable. And so what happens, they come back, and at some point in time, they give this suitcase, whatever it was, locked to Detective Busson so that he could copy whatever was in it. I think we've talked about Susan Miller and the fact that she had a very limited role, but a very important role here. And that is recognizing that when she looked at Curtis Reeves, you could tell that he had some injury and wanted to document it. John Ryder. He was the employee that was summoned over to the Cobb Theater in order to the hard drive. He did a pretty good job. Approached the deputy there and said, hey, I'm coming to get evidence, and the deputy just led him right through. Hey, remember what Mr. Peck told you? Yeah, that's exactly what he did. And you know what? When I got back from vacation in March, it was a brand new system. Silas Peck. We've talked about Dawn Simpson. She had absolutely no interest in anything in this case. She was there at the counter trying to get some posters for her daughter. And she told you without hesitation, when I looked over at Mr. Reeves, he waited patiently. When, I stepped over to the side and I heard that conversation, it was a conversation of a calm man, polite man, not an angry man. Matt Reeves. Likewise, a law enforcement officer for the Tampa Police Department. Who was the first one to come to the aid of Chad Olson? Matt Reeves. He was the one that caught Matt Reeves. They caught Mr. Olson. And summons another individual. Hey, help me! At that point in time, he didn't know who had a weapon, who didn't have a weapon. But he immediately went to work on Mr. Olson to try to save his life. And of course, he's a police officer. So he says, the police officer, he's a liar. When he came here and told you under oath, just a lie. So you know what? Disregard it. That doesn't matter. I submit to you that Matthew Reeves heard his father's cry. That day on January the 13th of 2014. What's shocking is that when Detective Smith interviewed him, and he diagram of what was taking place for Detective Smith. What did Detective Smith do with that diagram? Did we see it? Did we see that diagram? No. Detective Smith destroyed a piece of evidence that Matthew Reeves constructed for him. A witness there at the theater at the time of the event. Dr. Michael Knox.
Mr. Escobar, we
Yeah.
gotta take a break.
Yes.
Take 10 minutes, and okay, remember my instructions.
All rise, court is in recess for 10 minutes.
hang on a sec. All right, so what are we looking at? You know,
We've got two small clips.
how much time?
10, 15 minutes.
All right. I'm going to hold you to it because it's already been, well, it's 3 hours.
Jurors in the courtroom, Your Honor. You may be seated. All jurors are seated and present. Count four.
Thank you, Deputy. Ladies and gentlemen, we'll just be a few more minutes, 10, 15 more minutes before we have a lunch break, okay? Hang in there. Go ahead, Mr. Escobar. I'm going to
Sir.
relocate you.
Sergeant Duff, Deputy Demas, Roy Bedard. Remember their testimony, because it all matters. Roy Bedard, the only use of force expert that was presented today, gave you an opinion under oath that absolutely refuted the government's theory of prosecution. Their previous witness. Bruce Koenig. I'm going to show you two small clips that Mr. Koenig provided us so that you could see all the evidence. Matt? Go ahead. May I stop it right there? Who is it? Clear in the other row. Row A. Chad Olson. What's that? 1, 2, 3, 4, 5, 6. At that very moment. A coincidence? The phone? Or the shoe? If it's the phone, the phone. If it's not the phone, it doesn't matter. That's the one thing that doesn't matter, because where did we find that phone? In between Mr. Reeves' legs, immediately after the shot. They've given you absolutely no evidence as to how it got there. But if it was the shoe, and that leg was moving, it was moving for a reason. First attack. Next one, Matt. Stop right there. The best that we could give you in trying to really feel from seat number 9A what this gentleman was seeing was this. Matt, go through the progression, please. Ladies and gentlemen, this all happened within seconds. The actual shot, 0.72 seconds. Less than a second was the shot. And Roy Bedard, nationally recognized expert in the field of use of force, told you under oath that Mr. Reeves did not fire his weapon in response to the popcorn. Thank you. All right.
Ladies and gentlemen, we're going to go ahead and take a lunch break. Oh, don't do that. We'll take an hour for lunch. It's 2 o'clock. Be back at 3 o'clock if you would, please. And we'll get started again. Any questions? All right. Please remember my instructions during the recess. Don't do any independent research. Don't discuss the facts of the case amongst yourselves or with anyone else. And don't watch any news or media. Thank you.